Huh?
There's Eagles fan cell phone hanging through stuff.
What?
The Gary will be in touch.
Okay.
Yeah, sure.
All right. Stand back there close by.
All right. Back to the session, the Honorable Danielle Williams presiding. Make sure your cell phones are on silent. Have your headphones on silent prayer.
Thank you very much.
Thank you, vacancy.
No, I just figured up a couple of them. Matt gets out. Oh, what the hell? Yeah.
Carlo versus Tara Ayers. Are you Tara Ayers? Leave your mask up, leave your mask up. What are the last 4 digits of your social security?
3013.
One that.
Yes, sir.
What do you have?
Judge, I've met with Ms. Ayers and gone over her case thoroughly and then had a conversation with Commonwealth regarding that meeting. Unfortunately, one of my clients is tied up in the middle of this. I didn't even feel comfortable kind of arguing fully for her with the Commonwealth due to that association. So I don't have any choice but to ask my supervisors to consider conflict.
What's the comment saying?
No, I come forward, we have to, he's asking attorney, it seems like every time we get to the point we settle a case, and I'm getting ready to set at a trial, they get conflict counsel. It seems like every time to the point we can't get a settlement, and I'm getting ready to get a trial date, then Mr. Sheffield withdraws and gets conflict counsel. If he's got conflict, he needs to get out to start with. That's my point. I mean, we've been negotiating this case for 4 months.
Well, Judge, I'll say in response, thanks for the kind words from the Commonwealth, but in response is I try to resolve. I try to resolve cases before I get conflict counsel involved. So I'm trying to get cases done before we go to the, I'm not saying this case can't be resolved at some point, but we're at a point now where I feel like she needs an attorney who can lay blame to somebody that I can't lay blame to.
Co-defendants.
It's not a co-defendant situation.
No, I don't know how.
Judge, I'll be happy to go off the record and tell you, but, and I told Mr. Stockton in our conversation the other day.
Well, you mentioned the name. But I still don't understand. I mean, it's-
As I said,
And he
I
was
didn't,
one
as
charge.
I said, I didn't feel comfortable going into the full argument because of my duty of loyalty to the former client. Well, he was just in there.
Yeah, wait a second, does that mean that, I mean, most of everybody that's charged with criminal activity in Clinton County is a former fire officer.
Well, this is.
There's a difference between loyalty and ethical obligation.
Well, I feel like there's, in this particular instance, I feel like there's not.
I just asked for an in-camera review, but cover because I'm doing this, there's a ethical conflict.
Again, I appreciate the Commonwealth's vouching for my character, but.
We just have a disagreement over the ethical. That doesn't mean anything.
I just,
Okay, I'm gonna drop this case in the docket and I'll have it again here. Okay. Commonwealth versus Sherry Sue Barnes.
She knows to be here, so I don't know. Hey, she ought to be up there somewhere.
That's who she was downstairs coming in.
You have a phone number?
I don't have a number with me on her, I don't. Her mother's number.
Yeah, you should mention. Randy Bailey. Randy Bailey. Randy Bailey, 21 Sierra Hill. Are you taking that?
Yes, sir.
What's your year of birth?
Not too bad.
Last one is your social security.
9531.
What we got going on this, Mr. Stockton? Okay. Wrong, please. Is it down the podium? That's fair. A motion has been tendered that says you wish to enter a plea today, is that correct? Are you currently under the influence of drugs or alcohol? Is this plea freely and voluntarily? Are you the same person named in the indictment 21 CR 0018? Is your judgment impaired today? You need to speak up a little bit. Have you discussed this matter with your attorney? Are you satisfied with her advice?
Yes, sir.
Have you reviewed the evidence Commonwealth has against you before you move forward about your case?
Yes, sir.
You know, you do not have to enter a guilty plea today. You have certain rights under Kentucky United States Constitution. Before I can accept the plea, I need to know that you understand those rights. You have a right not to testify against yourself, no one can make you second. The right to speak, not to do, the right to listen to counsel, the jury trial. The right to confront and cross-examine all witnesses called to testify against you. The right to produce evidence, the right to call witnesses in your favor. The right to feel that the high court will lose, and I will provide a claim. You understand that you may plead that you give up. And I may consider the Commonwealth's recommendation, but I may apply any to sentence by the law. I do not have to accept any recommendation. Prior to accepting the recommendation, I will rescind investigation for the motion of parole. In the event that I do not accept the Commonwealth's recommendation, decide on the harsh sentence on it, you will have a right to withdraw your plea and proceed to trial. Who's going to present the Commonwealth's recommendation? I will. Now, step over to the right, both of them to the right. Okay.
Your Honor, the Commonwealth offers Ms. Beatty on a plea of possession of controlled substance first degree, a 3-year sentence probated for 3 years supervised, credit for time served. The defendant would pay court costs at your discretion and remain on active supervision until all restitution and costs are paid. After final sentencing, the defendant, along with co-defendants Sherry Barnes, Amy Angel, Eric Story, Lloyd Smith, agree to have all contraband destroyed, and the defendant would obtain gainful employment or do 30 hours per week community service.
Is that your understanding of the Commonwealth law?
Yes.
Has anyone included your attorney directly, of course, and anyone usually?
No.
You're in a guilty plea because you are guilty for no other reason, is that correct?
Yes.
Knowing the constitutional rights of persons who exclude your desire to pursue the plea in this case, no allow the court to fix your punishment.
Yes, sir.
You understand that he, at this guilty plea, any future convictions will enhance the enhancement of this plea. We have a document saying that pleader,
I do not.
this pleader.
You should have a lead.
I'm sorry.
Yeah,
I'm sorry.
you have a motion for the operating list,
No.
have a pass it, well, let's do that.
Oh, we're gonna have, we got the, Ross issue. You're here, all the cards, here, so you're. Clerk, most number of cards in the chief. Okay. Number 6. Number 38. Get forward. Number 8. Floor post. Okay, do you remember ever signing?
Yes.
Okay, well, let's start. Where were you when you signed this?
We got in the basin last month.
Did you have the one?
Don't have it.
Well, you have it. I'm trying to find out what happened.
Apparently Commonwealth says I did.
We always give them the things, and she's new over here, and we need to just keep up with it.
Yes, sir. Sorry, Your Honor.
Is that your signature that you signed it on the board agreement? Now, we're pre-sentence investigation for the probation parole, be back here on November 4th. Eddie Bowman. Rumble versus Eddie Bowman.
Your Honor, I'm standing in for Mr. Darrow on this motion for a speedy trial in this case.
Alder.
Yes, sir.
Baldwin Coleman.
Here she is, Your Honor.
What do we have going on this conference, man?
Both defendants have filed a motion for a speedy trial, and there's an outstanding issue with regards introduction of statements made as regards medical treatment of the child, which has been briefed by all the parties within the that.
Hey, Ron, the reason why we originally filed this motion is these two have not had contact with their child in 2 years. We got an order from this court allowing them to have visitation, but the social worker maintains that it's going to be against the child's best interest because they may go to jail if they're convicted. So the district judge, district court is refusing to let them see their child. So the only thing that we can do is move forward and have a trial and get the case resolved one way or another. So that's what we're asking for, the earliest trial date that we can get that works for everybody.
I just need a little time to line up Dr. Sugar. I mean, it's not like I'm dealing with a lady. that's here.
Sure.
Local.
Right.
Yeah.
Okay, well, I will. The parties, want to get in, we will not want to do to. It's just consult with us in their conversation.
You know what month I can ask her, look at it, whatever. I need some time frame. We can probably get a date, might want to contact her while we're open. Better say it. We can call her before.
There's like you suggested.
Let's just set it on top of that, he's supposed to pay that off today. Okay.
Okay, let's see. We got December 13th, 14th. We got a motion that we're gonna move that motion back to the 14th. And then the school year, Cal, 14th.
Yes, sir.
And I'll leave the 15th for one. This
We're
is
still having the current motion, but on the 16th.
Right. Now, Christmas falls, and New Year falls, following Thursday.
Yeah.
Your Honor, Mr. Farrell is scheduled for a mediation on 15th at 9 a.m. I'm concerned that this is going to be longer than a one-day trial due to the nature of the issues involved.
Well, it's easier to change the date of the mediation than it's jury trial, so why don't you consult with them?
Understood, Your Honor.
If they'll wait around, Your Honor, if there's a problem with Dr. Sugarman, we'll come back.
Commonwealth versus Connie Brown.
They're downstairs. There's some kind of issue going on. Shannon Marshall. Needs to be heard by that.
Well, there you go get it.
I'll go get it.
Any lawyers that are in the courtroom, I expect you will call us.
Your Honor, I will notify the court, I mean, interrupting, she is available. I don't know.
It's over here.
He's right outside.
What's his name?
Nathaniel Davis.
Nathaniel Davis. Commonwealth Kentucky versus Nathaniel Davis. Nathaniel Davis.
Yes, sir.
This is a motion to install interlock device.
Yes, sir, and we may have mislabeled, it's a motion to apply for an interlock device. The Department of Transportation will decide whether or not he's actually eligible. But we have to file this motion and have you sign that AOC form before they will determine his eligibility.
I have no objection. I checked his record and court made. It doesn't look like he's had any violations since this date, so I don't have any objection.
Okay, thank you. Okay, that's fine. I can do that.
Judge, that's all that I have. Can I be excused? Thanks, sir.
Cynthia Down. Cynthia Down. Versus Cynthia Down. Downey?
Yes, sir, I
What's your year of birth? Your year of birth,
am. 1958.
full mask up over your nose. For the last 4 digits of your social security.
6073.
Oh, yeah.
You got a plea for the court to consider.
The felony plea.
Yes, sir.
A motion has been tendered that says you wish to enter a guilty plea, Dave. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Sir?
Is the plea freely and voluntarily given?
Yes, sir.
Are you the same person indicted in indictment number 21 CR 0095?
Are you the same person?
Yes, sir.
Is your judgment impaired today in any way?
My speech?
Your judgment, is your
no,
judgment
sir.
impaired in any way?
No,
Have
sir.
you discussed this matter with your attorney?
Yes, sir.
Are you satisfied with his advice? Are you satisfied with his advice?
Yes, sir.
Have you reviewed the evidence the Commonwealth has against you?
Yes, sir.
You believe you're fully informed about the case?
Yes, sir.
You know, you don't have to enter a guilty plea. You have certain rights under Kentucky and the United States Constitution. Before I can accept the plea, I need to know that you understand those rights. You have the right not to testify against yourself. No one can make you say anything. You have the right to speak trial by jury. The right to be represented by counsel at the jury trial. The right to confront cross-examine all witnesses called to testify against you. The right to produce evidence. The right to call witnesses in your favor. The right to appeal this matter to high court if you lose. And the right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of charges against you. You understand that entering a plea today, you give up those rights. Now, I may
Yes, sir.
consider the Commonwealth's recommendation that I may apply any range of sentence allowed in the law. I mean, I have to accept the recommendation. Prior to accepting the recommendation, I will await free trial on the estimation report to more probation parole. In the event that I do not agree with the Commonwealth's recommendation and decide to impose a harsher sentence on you, you have a right to withdraw your plea. Now, what is each step to your left, man? Mr. Carter, what's the Commonwealth's recommendation?
The Commonwealth offers Ms. Downing on the plea of guilty of possession of controlled substance, first degree, 2 counts. For each sentence to run, each count to run 2.5 years for a total of 5, probated for 5. Credit for time served. The defendant will pay costs at your discretion, and stay on active supervision until costs were paid, and agree to have all contraband and controlled substance destroyed.
$155 on each time it sits. Is this recommendation what you agree to, man?
Yes, sir.
Are you pleading, enter this plea because you are guilty for no other reason?
Yes, sir.
And knowing your constitutional rights, I explained to you, it's still your desire. With those that enter this guilty plea, allow the court to put your punch.
Yes, sir.
Is that your signature on the document?
Fine. Sign this and sign the rest.
You realize that in this plea that any future felony pleas sentencing you enhanced. You understand that?
Yes, sir.
I will accept the plea or pre-sentence investigation and you are never to 4%. Okay? With probation parole.
Your Honor, may I approach the speech of the court? Bench, Brown. When you call, may I approach?
Yes.
Both downstairs. Sure. Well, she can wear long pants, long sleeves, she can cover up. Oh, I see, she's here.
Yeah, they're here. They're
Yeah, he's on the docket too.
Yeah, he's in worse shape than her.
What do you think?
Shannon Mercer, get him in, get him out. So, come on up. Carol, we're gonna put you on for there.
Are the Brown and Mercer cases two separate cases?
You called Miss Barnes earlier, she's present. She said she was coming up the steps when you called her case.
Okay.
Oh.
I'm looking at Peggy versus Connie Lucille Brown. Are you Connie Lucille Brown?
Yes, sir.
You're here today. I'm sorry, I'm only talking. What's kind of episode?
We have an offer.
Valley Police.
Yeah, no, it's diverse, please.
We have the paperwork completed, Your Honor.
Ms. Brown, you born in 1965,
Yes,
last 4 weeks, social security number or what?
4653.
Okay. Motion is in your decision, you wish to interview with me, is that correct? Are you currently influenced drugs or alcohol?
No,
Is this pretty freely involuntary?
I didn't hear you.
Is this plea freely and voluntarily?
Yes,
You have plenty of time to review the evidence and to talk to your attorney. Are you satisfied with his advice?
yeah,
You have certain rights under the Kentucky United States Constitution. Before I can accept the plea, I need to know you understand those rights. You have a right not to testify against yourself, no one can make you say that. The right to speak trial by jury, the right to be represented by counsel at the jury trial, the right to turn across the channel witnesses, called to testify against yourself, the right to use evidence. The right to call witnesses to the table, the right to know it's matter out, the right to fire the Commonwealth, who you are reason about your guilt. You understand that the end of the plea that you give up all these rights. Now, this is a pre-trial diversion, which means that you successfully complete the terms of pre-trial diversion. In case we dismiss pre-trial diversion, however, if you violate the terms of pre-trial diversion, you brought back in court, and it will be revoked, and then you'll be felon, and you'll be sentenced. In that case, this can be used in the future cases to get other felons. You have to understand that. You hold the document up there, is that your signature on that?
yes,
You'll all accept the pre-trial diversion, you'll need to make arrangements to meet the probation parole laws. He's sitting right there.
Oh, here.
Give her a phone number or something to call you.
I need to go over there.
Stay up there, you're going to do.
Wednesday at 7:30 a.m.
We just tell her, you tell her where you're standing there, just tell her.
I need you to be at Monticello Probation and Parole Office Wednesday at 7:30 Central Time. The address, phone number, if anything changes, call me. It's got instructions, fill this out, and this is instructions.
Okay, thank you. Mercer, you want to come around? Sit on that red spot right there. Are you Shannon Gill Mercer?
Yes, sir.
Okay. This is what we said, will be 20 CR 0034. You were born in 1975, sir.
That's correct.
And last 4 years, your social security number 5655.
That's correct.
Okay, then we're here on the free job conference. What's kind of that in this case?
Honor, we make an offer to clear the DUI for.
Your Honor, here's the situation on Mr. Murray. This is the case that the court may recall. The court overruled our suppression motion regarding operation. And due to Mr. Mercer's condition, we've not been able to get him in to see if we want to do a plea or a conditional plea or take him to trial. And due to his current situation, the court will bump this out in November and allow us.
I thought that when you said you was going to enter a plea.
But we would have the paperwork to take Mr. Krause. I thought we wouldn't have done that. Well, we never have firmed up what he wants to do.
Let's just get a trial date. This case will go on for 2 years. And he's. won't show up.
So we're plea offer is off the table.
We'll either live or die.
Okay.
The way you next worry about condition.
Okay.
Yeah, it's the 30s. They will. It's hard to make the call, Chad. What day do you allow it to 30? What day do you do? Maybe we'll go back to the basically, what for today. And we'll go outside and talk. Your Honor, will you let Mr. Mercer and I go outside and talk?
Sure.
Outside.
I know Alan Flint is dead, so this is not Candy.
No, it's not Candy.
Stephanie Edwards. Howell, Kentucky versus Stephanie Edwards. This is 21 CR 0074. Are you Stephanie Edwards?
Yes, sir.
Born in 1983.
Yes.
Last 4 digits of your social security number.
3473.
And he had an opportunity for probation for
Yes.
this is substantially correct. Is there any reason why this lady should not be sentenced?
No, Your Honor.
Upon pleading guilty to criminal possession of quarters first degree, you shall receive 5 years probation, 5 years. And shall pay restitution to the amount of $2,450.74 on a monthly basis, $200 a month. First payment being 30 days and you do.
I tried to ignore, and they don't have it in the system yet.
What is the time in this case? Court costs $55, additional $30 a month from time $200. Mr. Stockton, should this say that probationary period should be 5 years or until restitution?
Yes, it probably should. It's not fair.
No objection to that. So you'll be on probation to 5 years or until restitution.
pays it off, whether I don't mind taking it out.
Okay, thank you very much.
Your Honor, is there a restitution order in the file?
We'll look for it. Did you look at the file and see the restitution?
I've actually been told to try to pay $5,000 on the phone, and they can't find the system.
There's a second on the farm. You need to talk to Mr. Carson before you go. Sidney Foster. Sidney Foster. You raise your right hand and solemnly swear or affirm that you conduct your duties and I keep all matters there in confidence, protecting and Constitution. I do. Thank you very much. You go to the clerk. Okay. Sidney Foster. You should be able to. Justin Gibson.
No. Just an evening, just. Now, the one that's on for arraignment is, not the one that was brought.
Case number.
Oh,
We want to see our 00106.
There's an active one on
okay.
that.
Just need to make a misnote that this is the Wendell Hall. Commonwealth Kentucky versus Wendell Ray Hall, 21 cigars, 009. Mr. Hall, born in 1966. On the last 4 digits of social security, 60530. Is there plea offer?
There's a misdemeanor plea for the court to consider.
I need to advise the court what's going on.
Okay, let me go over this. Says you wish to approve. Is that correct? Yeah. Are you going to influence drugs or alcohol? No. Is this really voluntary? Maybe discuss this matter in return for like the vote on. Now, you have certain rights, so you have to match those constitutions, right, not each law. Some rights to the job, jury right, to work in the council, one person, you know, this is follow up, this service, right, like, this matter, how. You understand that, that included that you got those rights. And I want you to listen to the Commonwealth's recommendation, stick to your left service for this.
Your Honor, on this case, Mr. Hall was charged with operating motor vehicle license suspended, no registration.
once we investigated this case, Mr. Hall was on a moped less than 50 cc, so there's no license required, no insurance required. I checked with the clerk's office on that, so those charges will be dismissed. Also, there was an accident, he wrecked by himself. I guess he went to the hospital, we couldn't find any records showing impairment, there was no blood test done, no alcohol at the scene, no field sobriety test, so I'm just amending the DUI to warrant endangerment based on lack of evidence. I'm just not able. So, and that's the reason for misdemeanor. And the plea would be wanton endangerment, second degree, 12 months, probated for 24 months, credit for time served, and pay court costs of discretion.
$5. Yeah, you can pay that $30 a month. Riding a moped that place, you're not like anybody else, but you can hurt yourself, so you be careful. You never helmet.
No.
You know, if we are, I had a fight one time, I scratched some law, and something said, well, I was shooting. Well, time judge, just didn't seem like a thing to do. Get out riding that ground, you never did. Okay, you can, pay it in 30 days. You don't need to see me.
Is it not supervised?
Yes, sir.
Yeah.
You need to see the probation for a while.
Would say that.
Versus Jeff Hunley, 21 CR 0092, more 1961. Sure. 6004. What do we have here in common?
This is Cross report, I'm gonna make that.
We check trial lecture.
Just do one day. Yes, I would think so.
I'm trying to set it on, December the 15th. Thinking that we'll get the trial starts on the 14th, down on the 14th, for a minute and a half.
There's no way, based on our hearing that we had down the basement, there's no way we can set trial today.
Okay.
And I would think, based on the amount of questions.
Okay, that's fine. How about December the 20th?
That's fine. I'm available on the 20th, 12/20. Yeah, it'll be good.
Okay.
Okay, I'll talk with you later.
Cody Keith, 20 CR 004, Cody Keith.
Yes, sir.
Social Security report.
Yes,
And I understand you wish to have please.
Yes, we have a diversion for the court to consider.
Motion to file, Mr. Keith, it says you wish to have please, is that correct?
Yes.
Or currently, I think what was going on.
No.
But free and voluntary.
Yes.
Same person died in 20 CR 0049. The same person died in this case, 0049.
Yeah.
Show me the number on there.
What's your case number?
Wait, somebody got a phone going on here. Is your judgment carried today anyway?
No.
We discussed this matter with your attorney, review the evidence and patient that you've got to form.
Yeah.
Are you satisfied with his advice?
Yeah.
You have certain rights under Kentucky and United States Constitution before I can accept, but I need to know that you understand those rights. You have a right not to testify against yourself, no you make the same, you have a right to speak trial, but you have a right to represent the counsel to do trial. You have a right to confront the process and all witnesses called to testify against you, have a right to resist evidence, call witnesses to favor that process. You have a right to appeal this matter out of course to lose, and I apply the comment, because we are reading about it, you know, the charge of this. You understand that hearing guilty plea, then you give up all those rights. Now, I understand that there's a pre-trial diversion agreement here.
That's correct, Your Honor.
A pre-trial diversion is a successfully complete terms pre-trial diversion. In case you're dismissed, pre-trial diversion you get expunged. Now, if you violate the terms of pre-trial diversion, come back and I will vote for pre-trial diversion, have pre-sentence investigation board. If the sentence is convicted felon, and this will be used against you in future felony convictions. Do you understand that?
Yes, sir.
Is that your signature on the agreement?
Yes, sir.
Then you really agree, you understand?
Yes, sir.
You want to present it there and you need the probation parole officer with certain information. What are the court process for this? You need some time to pay it.
Yeah, when we were,
Much take $40 a month.
sounds
And then make the first payment for probation back. Scroll off, look. Michael Keith. Combo versus Michael Keith, 20 CR 0023. Second born in 1980.
Yes, sir.
Last four digits of your social security number 2969.
Yes, sir.
We need a trial date, Your Honor. We set this in January 10th, Your Honor. Those are those landlord unit cases. We don't settle this deed, that you did have to give this deed priority. Got a conflict on the 10th. About the way. It's district court thing, we can move stuff around, so. Since we're getting so many comments.
That's all I told.
Well, let me take a look at this. How long would it take?
I think this one could run into 2 days, I believe. It's possible. them.
What about Carmel versus Brown?
Yes, that, unless it gets continued by request of the defense, I think we've got everything in. On that, we got all of our allowance. That's a serious case. Yeah, it's a serious case. And if, or we can go later in the month.
Is William Child gonna go over it?
Yeah, I think what we'll do is the program is in federal custody, we'll just try this guy with the sheriff.
On 15, 16?
That'll make that trial short.
What about February 3rd and 4th?
I had to get somebody else to try.
I'm available one, 2 days.
When you got one, Carmel versus Ferguson. What about 7th and 8th?
That's fine.
Looks good to me.
Monty Allen. Carmel was 9 out of 3. 21 cigar deal. Yeah, the opportunity to recess the investigation. Is there any reason why this hearing should not be set? Who's your turn? This is Mr. Guy Allen. require any lapse in city heads review precinct investigation for essential connections.
No, Your Honor.
Following defendant's plea. Possession of no substance first degree. Since 3 years. Program. Information supervised. Not hurt for vehicle, influence.
He has 4 days. Yeah.
What's the cost? Realize the principle. All together. $960. Needs to have to pay that. $75 a month, sorry, birthdays. Now, Mr. Stockton. Yeah, what do you want to do about the 3 entities? It's big outside, we got 4.
He needs to have to do it.
Well, I understand, but we just can't,
I think that sets a bad precedent.
well, I understand.
I don't know if the court has discretion on the second or not.
I don't believe it, so.
Yeah.
Well, I don't know about the jail situation, about what kind of, how 4 hour when the best can turn in, so it's not as clear, we get better here.
I don't know. We don't have anybody from the jail here. We got to come and see what's person.
I'd ask for the court to allow him to report at 6 p.m. Friday and then be released, I guess, Monday. Yeah.
I can do that, I'm just trying to get in there when it's least crowd.
Well, they should be less after the day. There's a few going to be sentenced today, so they should get some relief after the day.
Okay, you can do that at 6 o'clock tomorrow. Kenny Mason. Commonwealth versus Kenny Joe Mason, 21 CR 0.
Ms. Jones and I have not had a chance to discuss this case since she's been appointed to conflict counsel. Can we have a negotiation day on November 1st at 1 o'clock?
Mark Kenny Joe Mason, we first negotiation, we return to Commonwealth and come back more than before. All those conditions we know.
Okay, can I get you back right there?
Matthew A. May. Matthew A. May.
Judge, we're on suppression here with that case.
21 CR 0014. Matthew A. May.
Yes.
Your Honor, this is the case we had set for a special day for a suppression hearing. Our witness was out of town. I don't know if the board wants to set another special day or wait on motion day.
This is what we need to know.
Okay, I hadn't prepared for it today, but
Well, he wants to sit on next.
yeah, let's do it the next motion day and I'll be ready. That's all right, Mr. White.
That'd be fine.
No bigger forward. And put it out.
1 o'clock on November 4th.
Second next, and that, that's it. 11:30 is the discretion.
That's right.
11:30.
We're sure that we'll put this in our experience. We are really sure. Shannon Mercer.
Please, Your Honor. Come on.
No, he's not touching it. I'm gonna get you that first. Larry, her gloves on, the merger's gonna sign off on that.
Sorry.
He's got to sign twice there, Larry.
The motion's been tendered that says you wish to remove the. We heard that any questions or alcohol.
Oh, sure. Yes, sir.
And the second person, maybe the guy that wants cigars.
Yes, sir. I didn't hear you, sir. Oh, sorry.
I said, I would ask you to come to come down.
Yes.
Believe that you've been fully informed about your case.
Yes, sir.
You understand that you're not going to go through certain rights under the United States Constitution. Your right not testifying, so no one can say anything about the speech, trial, jury, right to produce evidence. Not witnesses in favor, and that feels that higher force and account for reasonable doubt. That you are in charge, you understand that they view it those rights. Now, is this a felony plea?
It is, Your Honor.
Yeah, I mean, before, so I will have 3 cents investigation for that, with probation parole. When the rule goes, more time in the region is probably. No, it's like hearing when you go, the need to make sure. Don't you listen very closely to what kind of.
Your Honor, the Commonwealth offers on a plea to DUI fourth offense, the minimum 120 days to serve with the balance probated for 5 years. It'd be a 5-year plea, probated for 5, but he has to serve the 120. The minimum fines, which I believe is $350, but I don't have that written down in front of me, plus costs. And obtain gainful employment or do 30 hours of community service per week while under supervision.
Is that what you agreed to?
Yes, Ron.
Credit for time, sorry.
What it included also. $530, plus cost. Okay, well, have you heard these things, you agree that it's, is that your signature?
That's correct.
Yeah, I order a pre-sentence investigation for probation parole. We're back here on, November the 4th or something. Well, no wait sentence, so that's crossed and it completely wrong.
Going from there?
No.
Okay.
I need you to call Monticello Probation and Parole, the numbers on it, and ask Rebecca. Rebecca, explain to her what's going on, and ask her how she wants to do the PSI. Numbers on.
Thanks. You're welcome. Thank you. Commonwealth versus Walter Miller.
Right here, Judge.
Robert Lincoln Meyer. Commonwealth versus Robert Lincoln Myers. Who wants the Robert Lincoln Myers?
Yes, sir.
Born in 1967.
Yes, sir.
Last one is Social 37.
Yeah.
We did not, Judge, we have an offer on the table that I think might be something Mr. Meyer needs to strongly consider.
Let's put it on the negotiation one more time, if I did a superseding now, I think we need to discuss this.
There's a superseding indictment.
Well, maybe not, I don't know. Maybe we got one more negotiation now.
November 1st for negotiations. Next, November 1st for negotiations. And November 4th, next day, what other conditions you find?
Both of them at 9, both of them.
Billy Knox Perry. Pass, Mr. Perry, just that next. Tina Perry. Commonwealth versus Tina Perry. Commonwealth versus Tina Perry. When you see our availability, Tina Perry. Turn on. You hear me now? Commonwealth versus Tina Perry, 20 CR 00202. You hear the sentence, and you see the description of the probation role. And it's initially correct. We Is there any reason why this issue is sent to?
No, Your Honor.
Well, we guilty of that by all taking this whole finishes she said it was a very good thing. So Cheyenne Heritage. These first, according to this, 75. What costs in that? $100 a month.
We didn't pay the dollars on pay for.
What shows in the, as far as what shows being paid? She believes that the restitution has been paid in full.
That's one.
That's correct.
I know she's paid, she showed me a
In
receipt.
Cheyenne's name, we paid in Cheyenne's name, it wasn't.
Checking Cheyenne Heritage. Because it was joint and several, so.
I didn't agree with that, but Mr. Perkins had been on probation for quite a while and just got off. And I pretty much.
Okay, Jerry Parrish. Jerry Parrish.
Your Honor, I have Mr. Morris.
Jerry Parrish, 20 CR 1979. That's what it is, Social Security number five.
373.
You 17 year activity, precinct investigation for the.
Yes.
Not be substantially correct. The reason why this should not be sentenced.
No, Your Honor.
Upon plea of guilty, Patton controlled substance first offense. That shall be sentenced to 7.5 years probated with 5 years. That's it. It's 3 things, 2 days in jail, and 125 days. 24 days in. So, 255. First, 21. Will cost $155.
I can take it.
Jesse Phillips. Jesse Phillips, would you now Jesse Phillips?
Take care.
Carl Company versus Jason Phillips, 21 CR 001 Jesse Phillips. Yes, sir. 7, last 4 years, number on 8876. We hear that. What is the comment that said of this?
Judge, I'm here from the Glasgow office, the DPA office. Candace Hill just got this case. Mr. Berry retired, and this was his case. And it's been passed off to Candace Hill, and she hadn't had time to look at the case.
I didn't know who the conflict counsel was.
And so we're asking to pass it to November 4th, so Ms. Hill has an opportunity to speak with them.
Okay, we'll have a consultation day on November 1st.
Okay.
Negotiation day. And she'll be here on November 1st with her client, and then back on court day on
Let's say it at 9 o'clock. We got to talk to you about.
November 4th. Is what?
We can set this November 1st at 9 o'clock. She got a problem in her house. You see,
November first. Terry Phillips. Carmel versus Terry Phillips. Carmel versus Terry Phillips, 21 CR 006, Terry Phillips. Yes. Born in 1976. Yes. That's what it is. Supposed to be on 971. Yes. Here he is.
we had a place, I think, we don't have to.
Your Honor,
We spent about an hour and a half counting on this paperwork.
well, Your Honor, here's the situation Mr. Phillips is in, if the court wants to hear anything about this.
No, this is fine.
Well, yeah, then we can, if you want to set it out for trial, that's fine. We'd still like to settle it, but Mr. Stockton's made a very reasonable offer from the Commonwealth. Mr. Phillips is financially incapable of addressing it today. We hope the situation gets better very soon. You have a default judgment to sign today, which may help that, so.
Is the restitution issue?
Yes.
$300,000, and I agree with the burden, it's gonna be about $5,000 a month. And if he wants to pay less, we gotta do a felony.
It's, as I say, Mr. Stockton, from the Commonwealth's position, it's a fair offer, but Terry just can't afford to pay it until we try to get some of his money back from the third party that we have sued. He owes Terry over $600,000. He owes Mr.
Somebody else.
Yeah, that's right, that's 700,000, he owes me, I'm trying to get it, but I can't get no help to try to get it.
Is it county?
Yeah. We're having to try to collect it on our own. Prosecuting witnesses want Terry to pay them, and he
Now,
can't.
if we want to, we can keep it 1 month, we settle our trial, that's no more, I understand this one, next month, it's not resolved, I'll send the trial.
We'll know more.
We'll do it on the first and fourth.
I don't really need another negotiation today, but it's gonna sign the paperwork on the floor, so it's on the trial.
Okay.
You got here on November 4th, either settle this thing or have it out.
Understand. I'll call him. We'll get this, if he'll sign it today, he'll just enter today.
Shannon Portland.
That's all you have to watch. That's the one we need the rest of the people to sign so they can pay it off and then we'll pay it off. It's $5,000 plus the first.
Shannon Portland.
Oh, Shannon Portland.
Short prior. Hamlin versus Short prior. 21 CR 0059, Short prior.
Yes, sir. He's the one who did that.
More than 1962. last four digits, social security number 8761. What we got going on here?
Your Honor, we've had some negotiation. Commonwealth has made a couple offers from Mr. Pryor to choose from, and quite frankly, he's having trouble deciding, because one of them requires jail time, one of them is probation, and he's kind of weighing and he hasn't made a decision. I would ask if we could set him on.
However you make a decision today.
This is the one that was a superseding, that got confused.
There was a superseding
So I want
indictment.
to say it one last time.
You want to hear on the first negotiation?
Yes, Your Honor.
We
We
have
don't need to resolve the
November first for negotiation, and fourth, here for the regular city hall.
First and fourth.
Write that down.
Yeah. Both days, and both days, right as it.
Chris Sanders. Chris Sanders. No service. Chad Scott.
Okay, there's a Robin spot out there. I thought it was this.
Kamala versus Chad Scott. Chad Scott was 21 CR 0068. And Robin Scott was 21 CR 0069.
Now, we just got conflict counsel on Kenny Mason, and it's the other code thing. So I've asked if we could set on the first at 9 and 4 at 9.
Be here on November 1st at 9 o'clock for negotiations. And then 4th for the signature. Okay.
I got it. Okay. So we got a meeting next of our own. And then we got first and fourth, both of them, not like 9 AM, right? That's it.
We're gonna wait for signing.
What's that?
I'm gonna wait to do that.
James. I want first James Scott. Are you James Scott?
Yes, sir. Sorry.
Two copies.
Mr. Jones, we have a negotiation there, first and fourth.
We're on November 1st for negotiations and November 4th and the 12th. You need to meet, that's right, meet the attorneys and you cases negotiate on it. Okay.
We've been saying that at 1 o'clock.
Joe Turner. One CR 0065, are you Joe Turner?
Yes, sir.
165.
Yes, sir.
That's who is social security.
835.
No, retreat, Mr. Shepard.
Right.
Mr. Shepard, this is Joe Ed, the attorney.
Yes, sir.
identify yourself, we are the people like that. We are the one, that was common.
Your Honor, this is one that, I was having trouble getting a video to play. It was on me, it wasn't on well. But I've figured out how to play it now. Mr. Turner and I have set up a meeting for us to review that evidence.
November first,
Yeah, that'd be good.
we here on November first for negotiation, November fourth, that will be part of it.
So that's our, right? And then into the court. We're all going to.
Yeah. Alicia White. Commonwealth versus Alicia John White.
Yeah, I'm hard to hear, if I can tell.
Judge, we have an agreement in this case. There's a DUI third that's involved with the first 30 days in jail. She has a good job. She's been working that job for some time now, and she's not prepared and ready to go serve those 30 days today. The court allow us to let her in with a plea today and go serve that starting at sentencing.
Sorry, when
At sentencing, no, there would be no sentencing, because it's a diversion. My mind's off. Well, not much. How many days do you have in, Alicia?
It was just a few days. Oh, I'm sorry.
It's gonna be,
It was just a few days.
This is
I'm an inspector at Patriot. I've been there 11 months.
This is one where it's a third offense just because she barely got caught with a 10-year look back period. It's been a few years ago with the second offense.
well, I would say, just so they're in her plea next month.
well, that would accomplish the same goal as what I was asking.
That way we would see the precedent. But you come back on November fourth, and we need to bring two questions.
Okay.
Get ready.
Thank you. I appreciate it so much.
Jonathan Ray. Jonathan Ray. Jonathan Ray is a justice. Brown, is there?
No.
Who else do you have?
No. Very long, very long.
What about Billy Knox marriage? We can see. Come over to Sherry Barnes. Who wants CR 036, Sherry Barnes? Born in 1979. Last 4 days of Social Security in 4171. What we got to do?
Your Honor, this case was set for trial, and due to the illness and subsequent death of her father, the co-defendant, it was continued. I think Mr. Stockton and I need to meet on this case.
Yeah, I continued. She was supposed to meet with Mr. Cross on up there on October the 8th, but that was the day of her father's funeral, so I excused her from that.
So
So
November 1st, if you back up your negotiation on November 1st,
We'll allow today, like you want.
we'll be back in November 4th for negotiation on the 1st.
There are no clauses for
Cromwell versus Billy Knox Perry. Cromwell Perry versus Billy Knox Perry. Who wants to see our Billy Knox Perry?
Yes.
So, that's what it's Social Security number 67.
Yes.
Your Honor, we have a felon plea for consider.
Very understanding that motion file says you can reckon are you currently under the influence of drugs or alcohol? Pretty freely volunteer. Are you the same person that you can document 21 CR 078? Is your judgment impaired today?
No.
Have you discussed these charges with your attorney?
No.
Are you satisfied with his advice?
No.
Have you had plenty of time to review all the evidence? Cromwell has an issue where you're fully informed.
Yes.
You have certain rights under Kentucky United States Constitution, before I can accept it. I need to know that you understand. Your right not to testify, but you don't know to make a statement. The right to speak trial with your representation of the counsel to your trial, the Senate process, and all witnesses, all testify, and see that they said in the my sister's right to feel this matter how I feel. Will be on this. I mean, consider this is a felony plea.
Yes, Your Honor.
Consider Cromwell's recommendation that it's law. Law. If I do not accept the recommendation of the investigation will decide to impose harsher sentence on all such which belong to you. What is Cromwell's recommendation? So you said part of which
Your Honor, the Commonwealth offers on a plea of possession of controlled substance first degree, a sentence of 3 years probated for 5, and on a plea of guilty of DUI first offense under aggravating circumstance, a $300 fine plus cost plus 34 days in jail. Defendant would receive credit for time served, including contempt time, and be referred to the SSC for recommendations. Defendant would pay cost at your discretion, and all contraband would be destroyed.
Is that what you agree to, sir?
Yes.
You understand that hearings. I know your constitutional rights still here, sorry, and it's for a lot of work. Yeah, I will, order recess investigation or you back here sentencing on November 4th. That's your signature on the document. Yeah. Okay. We'll make some follow-ups about the Okay, we're ready for the court docket here. Dare County, are you on the line? Dare County. Martin County. Martin County, there you are. Commonwealth County versus Shane Caps. Are you Shane Caps?
Yes, sir.
21 CR 0001, Commonwealth County versus Shane Caps. Who represents you?
What?
Mr. Shevitz, do you represent Mr. Caps? Your attorney's getting online.
Okay.
Your Honor, this is a motion to revoke where Mr. Capps has got a new felony, and this is his second felony he's had on this same probation. Could you get me Carson's notes up there that's laying there?
Mr. Shevitz just now signing up here.
Okay.
Can I speak, Your Honor?
Not yet.
Okay, okay.
We're trying to get your lawyer online. I'm sure he's going to tell you not to speak.
Your Honor, I have not talked to Mr. Capps. I attempted to contact him through the Hardin County Jail yesterday and was not able to do so. I understand the Commonwealth, the bulk of the Commonwealth's substance of their motion involves a new charge that stems from Hardin County.
Mr. Capps, I know you got your hand up there, but you probably shouldn't say anything because it might affect this case without talking to your attorney.
Well, Your Honor, if I may, it might help and it might hurt, but tomorrow, me and my co-defendant is going in front of the judge, and my felony charges are going to be dismissed because it wasn't mine. I'm going to have 2 traffic violations. I just wanted y'all to know that. That way y'all knew what was going on because we're scheduled.
Wait. What we'll do here, I don't know why you're being held in jail there. What are you being held on?
He's got a new felony indictment, Your Honor, for failure to improper signal, possession of methamphetamine, possession of marijuana, and license not in possession. And he's also got a detainer on, and he's also got a detainer for the probation violation. So those are the outstanding issues.
Can I speak again, Your Honor?
Shane, I think you cleared things up for us. Judge, I would like to.
We can call us on Tammy. She's gonna have to call Ryan and we're gonna give you a number and all this stuff.
What is that?
That was Adair County. They muted. If Shane's accurate in what he says, I do think that makes a big difference as far as his position in this motion.
Can I say something else? May I speak, Your Honor?
Sure.
I just wanted to thank you, Mr. Stockton, for the opportunity for sending me up here. Because I can honestly say that I've kind of learned how to take care of myself. I've bought and paid for a vehicle.
Okay, wait just a second. Put your hand down.
Okay.
Mr. Stockton, if these charges against him are dismissed tomorrow,
They're dismissed, I would probably withdraw my motion to revoke, but until the meantime, I'd ask that a pen be placed on him to see what happens, because this is the second possession felony he's got while he's been on probation.
let's put a identification number on him and put a hold on him. Would you recommend that? Put a
Yes.
hold on him. And then, Mr. Shepard, if you'll keep track of what happens in court tomorrow, and if it's charged or dismissed, then you and Mr. Stockton can enter an agreed order dismissing this probation revocation. Okay? You understand that, Mr. Shepard?
Yes, sir.
Okay. Okay, thank you, Hardin County, for your cooperation.
Thank you, Your Honor.
All right, thank you.
Thank you, Mr. Stockton.
You're welcome.
KCIW, you on the line? Okay. Rotor, is Rotor on? Adair County, are you on? Adair County? We have Commonwealth versus Justin Gibson.
Mr. Gibson,
Gibson.
I was told just on Mr.
We have Candy Stuber, Justin Gibson, and Jonathan Stuber.
I got the Mr. Stuber here and Mrs. Stuber on the way. I didn't know anything about Gibson. This was kind of last minute to us.
Okay, well, if you could, we'll go ahead and take Mr. Steuben first. And then if you could send after Justin Gibson, we'll give you plenty of time, okay?
Thank you.
Commonwealth versus Jonathan Stuber. Commonwealth versus Jonathan Stuber, 21 CR 0024. Are you Jonathan Stuber?
Yes, sir.
Okay, your attorney, Mr. Sheffett, is on the line. Wave, Mr. Sheffett, so we can see you.
Hey, John.
What does the Commonwealth have to say in this case?
Your Honor, I have a motion to revoke bond in both his case and Candy Stuber, where they were arrested and charged in Cumberland County for trafficking. I've got, I guess it's Officer Tweedy now lined up to testify if necessary.
Okay, is Candy Stuber there also in the room?
I think the jailer went to get him.
Judge, we're aware of the charges in Cumberland County. I think a preliminary hearing was held last week, which would be basically the substance of this hearing as well. So I mean, I would stipulate to the fact that they got charged without making statement as to their culpability on the charges.
What do you have to say, Mr. Stockton?
Well, if that's sufficient for the court to revoke their bond, that's sufficient to me. And then we can get them indicted down there in Cumberland County and set a time for a global resolution or a trial date.
Okay. So you're stipulating
that they have new charges,
which includes drug paraphernalia, possession of controlled substance, first degree, prescription not in original container.
Okay, I'm going to go ahead and revoke them, and then you get them, indict them down in Cumberland County, try to roll it back together, okay?
Okay, thank you.
Okay, thank you. And now we've got, the only other thing we got in Adair County would be Justin E. Gibson.
We're bringing him up as we speak.
Okay, thank you. Just back there. I've got to stick it about it. I appreciate it.
Judge, I was
Yes,
informed that Mr. Joseph Gibson was released yesterday. He's no longer in our facility.
okay. Thank you so very much and for your cooperation.
Sorry about the wait.
We'll find him. Thank you.
Thank you.
Mr. Stockton, what's the situation on him?
My understanding is he was arrested for trafficking in Adair County. George Bertram represents him over there. His parents came to see me and he had a $10,000 cash bond over there. And my understanding is they put him into a long-term treatment facility. So I'm not going to pursue the motion to revoke bond at this time, but we will need to get him back here on a status conference, probably in either November or December.
I'll wait for you to docket it, okay?
Okay, thank you.
Okay. Is Roder on there yet? KCIW?
So we're here,
Okay, KCIW, we'll take you since you just have a.
10-4, let me grab her.
Have a seat in this chair over here.
This is Commonwealth of Kentucky, Clinton Circuit Court, 20 CR 00086 and 20 CR 0058, Commonwealth of Kentucky versus Angela R. Rains, also known as Angela R. Riddle. Is that correct?
Yes, sir.
You born in 1980, ma'am?
Yes, sir.
Okay. This is a shock probation hearing. Is that correct? You want to proceed, Mr. Sheffett?
No, she's pro se.
Pro se, are you? Ma'am, go ahead and tell me something then. Ms. Raines, you filed a motion for shock probation. You want to tell me about it?
Yes, Your Honor. I'd like to express, the decision of offering me shock probation while being locked up. I've had the opportunity to better myself as a person. Given the opportunity to shock, allow me to take care of my ill mother and just to support myself and her, just to know that I will be able to assist my mother in her everyday needs and doctor's appointments. Brings my heart great joy with all said. I appreciate everything you and Mr. Stockton's done.
Mr. Stockton, what do you know about this case?
I know her mother has malignancy, throat cancer. She's not in good shape. I originally probated Miss Raines so she could take care of her. And then she was arrested for a DUI in Cumberland County, and her probation was revoked. If the court does grant shock probation, I'd ask that she be placed under home incarceration for a while that she transitioned. The only reason I'm considering it is because I know her mother's a fine person, and she does need help right now. But if Miss Raines is going to get out, she needs to stay home and take care of her. She don't need to be out running around taking drugs and stuff. That's her problem. She's had a drug addiction for probably 15 years.
Ms. Raines, can you afford an ankle bracelet if I let you out?
Yes, sir.
Well, I'm going to shock probate you so you can take care of your mother.
Thank you.
But I want, as a condition of that, I'm going to put an ankle bracelet on you. Now, there's an old saying that no good deed goes unpunished. You've had a lot of different breaks now. The best thing you've got going for you is that you've got a mother with good reputation and is a good person. And I'm sure that if she has some illness, I hope it's not a terminal illness, but you'll get an opportunity where you won't be a disappointment to her anymore. You understand what I'm saying?
Yes, sir.
If you come back here, don't ask for any other breaks. I'll enter an order today, and somebody in your family needs to start helping you make arrangements for an ankle bracelet.
Your Honor, could we review it like in 90 days? If you could put it in order for like January or something where we can review it and see if she needs to stay on it or not.
Okay, I'd say let's put her on at 60 days to review it.
Okay,
I'd come back here on December the 2nd to review. You be in court on December the 2nd. And you'll be supervised, okay? So probation and parole will be in contact with you. Okay, KCIW, thank you very much for your cooperation.
Thanks, sir. To contact Monticello Probation and Parole when she is released.
Well, as soon as you're released, you need to contact Monticello Probation and Parole. You know where they are.
Yes, sir.
Okay, thank you.
Thank you.
Yeah. I guess we can go to Russell County. They don't seem to be on there. Wayne County.
you got a lot of money.
Wayne County, I see you on there. Will you activate? Do what? Wayne County? Okay, Russell County, are you on? Go to Clinton County. Clinton County. Wayne County, come back on. I saw you there for a second. Wayne County, okay.
Where?
Sarah Cash, you have Sarah Cash there?
I've got the males in here at the moment, Judge.
Okay, I'll start with the males then. Benjamin Clable. Commonwealth versus Benjamin Clable. Are you Benjamin Clable?
Yes, sir.
Okay, were you born in 1986?
Yes, sir.
Last four digits, your social security number 2415.
Yes, sir.
Okay, who represents Mr. Clable?
I do, Judge.
Shepherd. What do we have here, Mr. Commonwealth Attorney?
I don't know. I can't remember Mr. Shepard not having any conversations. I'm not saying we did, but
I think we talked about setting him on the 1st and
okay.
Okay, we'll have a negotiation day for you, Mr. Clable, on November 1st. Your next court day will be on November 4th. What's Mr. Clable being held on, this case or something else?
Judge, he's held by this case on the 9th of September. It's my memory as well. I talked to Gary there and also Ben. It's their memory that the court's ruling at the time is that the court was going to allow the district court bond that had been posted, which was a $50,000 property bond. The court was going to allow that to stand for the bond in these two cases. And I guess there was never an order done, or there was never anything that indicated that that was the case. So he's remained in custody since the 9th. I would ask the court, I'll submit an order this afternoon. If the court
I was thinking he also, I requested an ankle monitor if he was released on.
I think you're right. I think you're right, Jesse.
Brad, does he still have a fugitive holder? I'm showing he has a fugitive holder. Is that still?
He's got an ROR on his
Okay.
on his Tennessee case, so he's not held by that. Is that still correct, Mr. York, Sergeant York?
Judge Lawson gave him a 2,500 unsecured.
Unsecured, okay.
Yeah.
So he's got a $50,000 property bond.
He posted it in district court.
Okay, well, I'll allow that to stand for his appearance here. And once that's made, he put an ankle bracelet on. He'll be here on November 1st for negotiation and November 4th for a court date. So the bond will be just transferred over, Mr. Clable. So
Judge, do I need to do an order, or will a docket entry suffice for that?
Well, we don't do docket entries much, so just do an order with the ankle bracelet in there, and that way we'll send that to the jail over there, okay?
Okay.
And you ought to be able to get out today, Mr. Claywell, and I guess, how will he make arrangements to get the ankle bracelet? As soon as he gets out, he needs to.
He needs a.
Well,
Give Bookout a call and he'll come up here and hook him up before he gets out.
That'll be a good deal. Okay, thank you very much.
And Ben, hey, Ben,
Yes, sir.
November 1st and November 4th are your court dates, okay?
Yes, sir.
Okay, Luther Connor.
They said Luke Connor.
Ain't he in there? No. 157. Hey, they went to get him.
Jesse didn't Miss Jones represent Mr. Connor?
Yes.
Okay.
Yeah, she's out there in court.
Okay.
That clock, we need to reset that clock.
No.
Well, yeah, another month.
Commonwealth of Kentucky versus Luther Connor. Are you Luther Connor?
Yes, sir.
This is 21 CR 0034. What do you have, Mr. Stockton? Your microphone's off, Mr. Stockton.
I thought we have a plea, pretrial to verdict.
Okay. A motion has been tendered, Mr. Connor, that says you wish to enter a plea. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes, sir.
Are you the same person named in indictment number 21 CR 0034?
Yes, sir.
Have you discussed this matter with your attorney, and are you satisfied with her advice?
Yes, sir.
Have you reviewed the evidence the Commonwealth has against you, and you believe you're fully informed about your case?
Yes, sir.
You know, you do not have to enter a guilty plea. You have certain rights under the Kentucky and United States Constitution. Before I can accept a plea, I need to know that you understand those rights. You have the right not to testify against yourself. No one can make you say anything. You have a right to speedy trial by jury, the right to be represented by counsel at your jury trial, and the right to confront and cross-examine all witnesses called to testify against you. You have the right to produce evidence, right to call witnesses in your favor, and have process issued to compel their attendance. You have a right to appeal this matter to a higher court if you lose, and a right to acquire a Commonwealth to prove beyond a reasonable doubt that you're guilty of charges against you. You understand that by entering a guilty plea, you give up those rights. I understand that this is a pretrial diversion. Is that correct, Counselor?
Yes, sir.
A pretrial diversion means if you successfully complete the terms of pretrial diversion, the case will be dismissed pretrial diversion. However, if you violate the terms of pretrial diversion and brought back to court, and that's so fine, I'll revoke the pretrial diversion, order pre-sentence investigation report. You'll be sentenced. At that time, you'll be a convicted felon. And this plea could be used against you to enhance sentences and other felonies. Do you understand that?
Yes, sir.
Knowing all the constitutional rights I've explained to you, that you're still your desire to go ahead and enter a plea in this case.
Yes, sir.
You are pleading guilty because you are guilty?
Yes, sir.
You know, there've been a couple of documents here. Will you hold that up to that device over there? This device, which one are we shooting at? Right there? Okay, hold it real up close to it. Is that your signature on there, sir?
Yes, sir.
Okay, well, I will go ahead and sign the pretrial diversion. Or is he being held on any other?
He's being held, he can be oriented for drug court.
He's getting out tonight at 6 o'clock on drug court, Jesse.
Okay, good.
Okay, well, I'll sign the proper documents when you finish when you get it admitted to drug court and send it over to the jail at that time. And then I guess he needs to go ahead, even though he's going drug court, he'll need to contact probation and parole office over at Wayne County upon your
Probation and parole is going around and see him before he's released this afternoon.
probation and parole will be over to see you this afternoon, is what they tell me, okay?
Yes, sir.
Okay. Thank you very much.
You can have it 6 of them.
Yeah, that's the one we're waiting for.
Okay. Guess the next person is John Diamond.
They need John Diamond, Mr. Jordan.
They need John Diamond?
Yes, sir.
They want to get him. Give me John Diamond up here.
Do you have anybody else in there till we get in? Tim Kelly, are you there?
Oh, no, sir.
Was that, are you John Diamond?
No, Austin Reed. They gonna get him, sir.
Okay.
This is a new form.
We'll take a short break here and I have to go down and wait on the grand jury till we get everybody started again.
We're going home now. I'm like, I went on the grand jury. We ain't needed those. Big Bear. Go ahead and get up, Mike. They took a break now, Bear. They take a break? Yeah, you might want to mute it. You need Tim Kelly too.
Hey, Jesse. Can you hear me? This is Lee Wittenberg.
Yeah, I can hear you.
Do you think they'll be able to get Richard to the video since we didn't know he was actually up there?
Where is
he? He's in Rotor.
Oh, I don't know. You could call and see.
Well,
Megan, are you hearing this?
Yeah, I did not know he was in Rotor until this morning, so I didn't have a contact for them.
You want to just do it next month, Lee?
That'd be fine. Just renotice it and we'll do it next month. That way maybe we can give them notice so he can be available.
Is that all right, Megan?
Yeah, that'll be fine. I'll just let Judge know we passed it to next month.
Okay. Thank you, Jesse.
Thank you. Richard Guthrie. He's in Rotor.
Well,
We'll take care of it. It's called. Tell the judge he's muted. Yeah. There you
Okay, that's good.
go. Okay.
Wayne County,
Yeah.
John Diamond,
Part of the thing right here. Okay. Yes, yes, Your Honor.
Commonwealth versus John G. Diamond, 21 CR 0054. Are you John Diamond?
Yes.
We're here today for sentencing. Your attorney, Mr. Cross, is here. You can see him there. Have you had an opportunity to review this pre-sentence investigation report done by probation and parole, Mr. Diamond?
Yes, sir. I started to look at it there.
Is it substantially correct?
Thankfully, yes, Your Honor.
Okay, is there any reason, Mr. Cross, this gentleman should not be sentenced today? Upon his plea of guilty to assault third degree, 3 counts, the defendant shall receive a sentence of 5 years on each count to run concurrently for a total of 5 years. On a plea of guilty to criminal mischief first degree, the defendant shall receive a sentence of 5 years. The 2 5-year sentences shall run consecutively for a total of 10 years, serve 180 days in jail, in addition to the home incarceration already served, with the balance probated for 5 years supervised. On a plea of guilty to operating a motor vehicle with alcohol and concentration of 0.08 or under the influence, aggravating circumstances, he shall serve 4 days in jail, pay a $300 fine plus cost. On a plea of guilty to criminal mischief, he shall serve 60 days in jail. The 180 days, 60 days, and 4 days in jail shall run concurrently for a total of 180 days. Defendant shall receive credit for time served in home incarceration, but must serve an additional 180 days in jail. Defendant shall pay restitution matter of $400 to Officer Rick Riddle plus $3,200 to Albany Medical Center for a total restitution $3,600 to be paid to the circuit clerk's office, $200 a month. First payment being due 30 days after the release from incarceration. Restitution to be dispersed to Officer Riddle and then to the Albany Medical Center, subject to 5% restitution fee. What are the court costs involved? Court costs $155, and I'll add $30 a month onto the 200. So it won't break it. Okay, and when you get out, probation, parole will be by to see him, is that right?
I'll be over to see him. He's only got 30 days.
Okay, probation, parole will come over to see you when it's time. They say you got 30 days jail credit, so when it gets closer, they'll come see you, okay? Thank you.
Thank you.
Yeah. Kelly Thompson, Timothy Kelly, though, rather. Timothy Kelly. Timothy Kelly. Commonwealth of Kentucky versus Timothy Kelly, 21 CR 0053. Are you Timothy Kelly?
Yes, I am, sir.
Born 1975.
I am, yes.
The last four digits of your social security number are 5898.
Yes, sir.
He's going to 103.
Judge, he was on for sentencing last month, and part of the plea was to pay restitution prior to final sentencing, and it hadn't been paid, so we continued it out until this month, and he has been incarcerated on some other charge since then.
Yeah, he's never paid the restitution, Your Honor.
Okay.
So I just asked that we set the plea aside and set it for a pretrial. He's being held in, I understand, Wayne County indictments and federal indictments. He's got a federal indictment.
My understanding is.
You need to speak up.
My understanding is that the plea was contingent on a certain amount of restitution to be paid by a certain date. That's not been done, so we don't have any predicament to set the plea aside. Federal indictment as well.
Timothy Kelly.
Okay, well, I'll reject the plea agreement. And when you want to set it for, Mr. Stockton?
Let's set it for next month, and I'll see the status on these other cases before I get a trial date.
November the 4th, your next court date. Yeah. Barbara Neal.
I still got males in here, Judge.
You just tell me who you got in there. I can't see them or anything.
I got Jonathan Ray.
Okay, Jonathan Ray will be next.
That's the guy that has to turn himself in on Friday.
Oh, there
Yeah,
it is.
because the
There.
post office is
Okay, I didn't
closed
see it.
tomorrow.
Okay. Commonwealth versus Jonathan E. Ray, 21 CR 0083. Are you Jonathan E. Ray?
Yes, sir.
We're here on a pretrial conference. Who represents Mr. Ray?
Brad Sutton.
Mr.
I say,
Shepherd?
Judge, on 21 CR 105 is actually an arraignment, I believe. He was arraigned on 83 over in Cumberland County a few weeks ago.
It should be right now.
Yeah, it's on the docket wrong. So, Mr. Ray, what year were you born?
86,
What's the last four digits of your social security number?
4463.
You're here today for the purpose of arraignment. The grand jury of Clinton County has returned an indictment charging you with tampering with prisoner monitoring device and being a persistent felony offender. Do you understand those charges?
Yes, sir.
Mr. Sheffield, you represent him. Do you acknowledge receipt of indictment, waive formal reading and arraignment, acknowledges identity, enter plea not guilty, reserving all pretrial motions?
Yes, Your Honor.
You know, so we have two cases. We have the case that was transferred over from Cumberland Circuit Court.
No, we just heard it.
We just heard it right there. Okay, I'm sorry. 21 CR 0083. and 21 CR 00105. I'm signing a reciprocal discovery order on the new indictment. Mr. Commonwealth Attorney, you wish to schedule this?
Yes, for November the 1st. For this conference.
Put both of these cases on November 1st for negotiation. The next court date is on November the 4th. Okay, thank you very much.
Was Brad gonna ask about the bond hearing?
Judge, I believe in the new bond, he's got an unsecured or an ROR, but he's being held by, in 83, he's being held by, I believe it was a 10,000. Is that right, John? 10,000 cash?
Yeah, 10 cash, 20 property.
2 times property.
Yeah, and I got on that new case, just got a OR and house arrest on that.
Mr. Ray believes he could make a smaller, like a $5,000 property bond if the Commonwealth and the court would consider that.
Well, it appears to me that he's charged with tampering with a device on a previous bond. So that would have been a bond violation, wouldn't it?
I would think so.
Well,
He could be held without a bond.
Yeah, y'all just negotiate that. I'm not going to change the bond. Okay. Thank you very much.
I got Joseph Payton.
Okay. Joseph William Payton. Commonwealth versus Joseph William Payton, 21 CR 00102. Are you Joseph Payton?
Yes, Your Honor.
In 1976.
Yes, Your Honor.
Last 4 digits of social security number are 8810. Is that correct?
Yes, Your Honor.
Is this an arraignment here? Okay, you're here for the purpose of arraignment. You have a right to remain silent. You represented, Mr. Sheffitt represents you?
Yes.
Okay. The grand jury of Clinton County has returned an indictment charging you with fleeing or evading police first degree on foot, trafficking controlled substance first degree, trafficking controlled substance first degree, another charge, drug paraphernalia. You understand those charges?
Yes, Your Honor.
Mr. Sheffitt, you acknowledge the identity of Mr. Payton, receive the indictment, waive formal reading and arraignment, enter plea of not guilty, preserving all pretrial motions.
Yes, Your Honor.
We'll schedule him for the 1st of next month and the 4th for first for negotiation and the 4th for entering a plea for second trial date. I'm signing a reciprocal discovery order on that case to get the information to you.
Mr. Sheffield, is he going to?
What's the bond situation, this gentleman?
Judge, it's 10,000 cash or twice property with an ankle monitor.
Honor, based on the facts of the case, I believe that's a reasonable bond. He had allegedly had in his possession 50 grams of meth and 8 grams of heroin. So with the enhanced penalties for heroin now, that's a reasonable bond, I believe.
Yeah. Well, if y'all can schedule a bond hearing until then, I'll keep it the same, okay?
And Mr. Sheffield, you was going to ask about the personal property?
I'll address that with the Commonwealth at our negotiation day on the 1st.
All right.
Thank you. You got any other males there?
Austin Reed.
Austin Reed, Commonwealth versus Austin Reed. 20 CR 0059. You are Austin Reed.
Yes, sir.
1999.
Sir.
Last 4 digits social security number are 4305.
Yes, sir.
Okay, what do we have with the Commonwealth here?
Your Honor, it's a motion to revoke probation. He got a 5-year sentence for burglary over a stolen cell phone. Since he's been on probation, he's gotten 3 misdemeanors, either driving without a license, revoked license, no insurance, and 1 DUI second. I spoke with Mr. Sheffield. If the court's agreeable, the Commonwealth's willing to put him into drug court if he will go and stay in there until he's oriented.
Yes, sir.
Mr. Reed, are you willing to go into drug court?
Yes, sir.
Okay, well, I'll sign the orders, get him evaluated. When it gets time to release him into the drug court, I'll sign the documents, okay?
Hey, Megan, I think I emailed you a referral yesterday on that.
Yeah, well, she says she had, Mr. Reed, You're running out of options here. This drug court will serve you well if you'll get in it and participate seriously in it.
Yes, sir.
Back on track, okay?
When y'all think y'all be able to get me going in it?
I'm signing the referral right now, and then they'll come over and interview you and that sort of thing just as soon as possible, okay?
All right, thank you.
Okay. Now, I guess we're to the female prisoners now. I guess we got April Payton and Barbara Neal.
And Sarah Cash.
Cash, okay. Sarah Cash, you there?
Yeah.
Commonwealth versus Sarah Cash. 21 CR 0039. You are Sarah Cash.
Yes.
You're here today for the purpose of sentencing. Have you seen the pre-sentence investigation report done by probation and parole?
Yes, sir.
It's substantially correct.
Yes, sir.
Is there any reason why Ms. Cash should not be sentenced today, Mr. Shepard?
No, Your Honor.
Okay. On a plea of guilty to traffic and controlled substance, first degree, first offense, Ms. Cash will receive 7.5 years to serve. The defendant shall serve 180 days in jail, and the Commonwealth will agree to shock probation on the condition that she enter and complete the Clinton County Drug Court or Specialty Court program. Defendant will forfeit $227 to the Commonwealth to be dispersed according to the forfeiture order. She shall pay for costs in the amount of what? $155. I'll allow you to pay that $30 a month, starting 30 days after your release. And I'll sign the referral on the drug court program.
Okay.
Okay? And you'll need to, I guess they'll come and interview, probation parole will come interview, is that right?
Once she is granted, once the shock order is entered, I will see her before she goes there.
Okay. When they enter the shock order, when the shock order gets entered, they'll come and see you over there, okay?
Okay.
Okay, thank you. Barbara Neal.
Megan, you should have that referral order momentarily.
Commonwealth versus Barbara Neal. 20 CR 0080. Are you Barbara Neal?
Yes.
You're here today for the purpose of sentencing. Ms. Neal, have you looked at the pre-sentence investigation report done by probation and parole?
Yes.
Found it to be substantially correct?
Yeah.
Is there any reason why this lady should not be sentenced?
No, Your Honor, I would ask the court to, as the court, I'm sure will do, is to consider probation. She had a diversion voided after failure to complete drug court. Ms. Steele has a limited criminal history and is local residents, and I think she could be supervised in the community without issue.
Mr. Stockton, what do you have to say?
Your Honor, she was terminated from drug court. At this time, the Commonwealth would oppose probation. Give me her file.
Pretrial diversion was voided on September 9th, 2021. 3 years there. You shall be sentenced to 3 years to serve. Of course, you still have the possibility of filing some motions for shock and that sort of thing in the future.
Your Honor, she was terminated. She had 6 positive tests.
I've already.
Yeah, I was just going to say, if she does file a motion, I think long-term treatment might be appropriate sometime down the road if she did file a motion.
Okay, 3 years. I hope you get some help while you're in there, and then you'll stay in contact with your lawyer, okay?
Okay.
Thank you very much. April Payton.
Where's my
Commonwealth versus
computer
April
case?
Payton, 21 CR 00103. Are you April Payton?
Yes, sir.
You're here today for the purpose of arraignment. You have a right to remain silent. Your attorney, Mr. Shepard, is there if you see him. The grand jury of Clinton County's returned an indictment charging you with fleeing or evading police on foot, traffic and controlled substance first offense, 2 counts, and possession of drug paraphernalia. You understand those charges?
Yes, sir.
Mr. Shepard, do you acknowledge the identity of Ms. Payton, receipt of indictments, waive formal reading and arraignment, enter plea of not guilty, reserving all pretrial motions?
Yes, Your Honor.
What's Ms. Payton's bond?
Same as co-defendant, Judge, 10,000 cash, twice property with an ankle monitor.
Okay. Well, I'll let the Commonwealth and a reciprocal discovery order, ma'am, so they'll send you the information so you can prepare your defense. I won't change the bond, but you have a right to 1 motion for bond reduction. Your attorney will be in contact with you. Maybe he'll contact the Commonwealth and see if they can reach some agreement. If not, you can schedule a hearing. Should be back in court. You are on negotiations for November 1.
Yes, Your Honor.
Negotiations on November 1 and your next court appearance, November the 4th. Both of them conditions of bond. Thank you very much. Now, is Russell County ready now? Russell County, are you ready?
Yes, sir, we are.
Thank you, Wayne County, for your cooperation. I don't think we have anybody else over there with you. Thank you for cooperation. Russell County will be, you want to do the females or the males, or what do you want to do, Russell County?
It doesn't matter, whichever. They're
Okay.
all in here right now.
Okay, Commonwealth versus Amy Angel. Wait just a second till I get her in front of it. She can see you there. Commonwealth versus Amy Angel, 21 CR 0037. Are you Amy Angel?
Yes, sir.
Are you born in 1980?
Yes,
Last 4 digits, social security number 5443.
yes.
Now, Miss Angel, your attorney is here today from a conflict attorney from the Office of Public Advocacy. Sir, you have something to say?
I do, I'm here for Candace Hill, she's gonna be representing, Ms. Angel here for, and, Ms. Hill will be here today, she has to ask this.
This gentleman says that your new appointed attorney is Candace Hill, who had a conflict. You want to hear on the first, Mr. Stockton?
Yes, Your Honor.
Okay, you'll be in court on November 1st for negotiation here, and then on November 4th, your next court date, to see if you can enter a plea or if you want to set a trial date, and the attorney will be in contact with you, Ms. Hill, okay?
Can I be released to go home?
Well,
Your Honor, I think she's
go ahead.
failure to appear for a pretrial conference and her court date.
Yeah, you'll have to talk to your
Supposed to be
attorney.
under
Wait.
quarantine.
Wait, you'll have to talk, your attorney will call you and then you explain what happened to her and she'll get a hold of Commonwealth. If they reach an agreement, I'll consider it, okay? Thank you very much. Ronald Daniel. Ronald Daniel. Commonwealth versus Ronald Daniel, 21 CR 0033. Are you Ronald Daniel?
Yes, sir.
And there's also 21 CR 00101, which is an arraignment. In that case, you're here for the purpose of arraignment. The grand jury of Clinton County's returned an indictment charging you with traffic and controlled substance, first offense, criminal trespass, and being a persistent felony offender. Counselor, do you acknowledge the identity of your client, receive the indictment, waive formal reading and arraignment, enter plea of not guilty, reserving all pretrial motions?
Yes, sir.
Okay, now have you resolved all these cases into one thing here? Is it what you've done or what?
Yes, Your Honor.
Okay, Mr. Daniel, I understand the motion's been said to consolidate these two cases or at least enter a plea agreement with both of them. Is that correct?
Yes, sir.
Okay, are you currently under the influence of drugs or alcohol?
No, sir.
Is the plea freely and voluntarily given?
Yes, sir.
Are you the same person named in indictments number 21 CR 0033 and 21 CR 00101?
Yes, Your Honor.
Have you had plenty of time to discuss this matter with your attorney, and are you satisfied with his advice?
Yes.
Have you reviewed the evidence the Commonwealth has against you? Do you believe you're fully informed about your case?
Yes, sir.
Realize you do not have to enter a guilty plea. You have certain rights under the Kentucky and United States Constitution. Before I can accept a plea from you, I need to know that you understand those rights. You have a right not to testify against yourself. No one can make you say anything. You have a right to speedy trial by jury, the right to be represented by counsel at your jury trial, the right to confront and cross-examine all witnesses called to testify against you. The right to produce evidence, the right to call witnesses in your favor, the right to appeal this matter to a higher court if you lose, and the right to require the Commonwealth to prove on a reasonable doubt that you're guilty of charges against you. Do you understand that by entering a plea of guilty, you give up all those rights? I may
Yes, sir.
consider the Commonwealth's recommendation, but I may apply any sentence range as allowed by law. Prior to accepting the recommendation, I will ask for a pre-sentence investigation report to be done. In the event that I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence, you have a right to withdraw your plea if you want to in that situation. What is the Commonwealth's recommendation, Mr. Stockton?
Your Honor, in indictment 21 CR 33, Mr. Daniel will plead guilty to possession of controlled substance first degree, receive a sentence of 1.5 years. In indictment number 21 CR 101, he'll plead guilty to charge of trafficking in a controlled substance first degree, receive a sentence of 6 years. Those two sentences shall run consecutively for a total of 7.5 years. He'll serve 180 days in jail. Commonwealth will agree to shop probation on the condition the defendant enter and complete the drug court program after he served 180 days total. He shall forfeit $132 to the Commonwealth of Kentucky. He will also not be prosecuted on the charge of promoting the contraband which occurred at the Clinton County Jail on August 11th. His credit from time served shall begin July the 25th. He shall pay court costs at discretion of the court, and all evidence in this case will be destroyed.
Is that what you agreed to, sir?
Yes, sir.
You understand by entering this plea, you become a convicted felon. If you have any felonies in the future, they could be enhanced under persistent felony offender law. You understand that? Pleading guilty because you are guilty and for no other reason.
Yes, sir.
Okay, you understand your constitutional rights. Is that correct?
Yes, sir.
Okay, will you hold that document up? Is that your signature on there?
Yes, sir.
Okay, I will accept the plea, order a pre-sentence investigation report be done by probation and parole, and schedule your sentencing for November the 9th. Okay,
All right. Thank you, Your Honor.
thank you very much.
Apologize, I can't hear very well. Is it November 9th?
I might have said 9th, it's November the 4th. You heard very well.
At what time, Your Honor?
9 a.m.
Yes, sir. Thank you.
Okay,
Your Honor, is there any way you consider let me do the rest of this 180 days on house arrest?
you'll have to talk to your attorney, and at the sentencing, we can discuss that, okay?
Thank
Okay, thank you. Amanda Jewell. Amanda Jewell.
Jesse, this is a case where we had to change the paperwork a little bit this morning.
Yeah, I'll try to do my best with it.
Commonwealth of Kentucky versus Amanda Jewell, 21 CR 0075. Are you Amanda Jewell? Born in 1988? You have to speak up.
Was in there.
We're here today for a pretrial conference. What does the Commonwealth have to say?
Felony plea, Your Honor.
Okay. Ms. Jewell, I've been informed that you wish to enter a plea today. Is that correct?
Yeah.
I'm gonna take this off. If you want to step away.
It's not out there on the.
Take it off. A motion has been tendered, says you wish to enter a felony plea. Are you currently under the influence of drugs or alcohol? Is this plea freely and voluntarily given?
Yeah.
Okay. Are you the same person named in indictment number 21 CR 0075?
Yes.
Is your judgment impaired today in any way?
No.
Have you had plenty of time to discuss this matter with your attorney? You feel like you're fully informed about your case?
Yes, Your Honor.
Have you reviewed the evidence the Commonwealth has against you and you believe that, and you are satisfied with the advice of your attorney after that review?
Yes.
You have certain rights under the Kentucky and United States Constitution. Before I can accept a plea, I need to know that you understand those rights.
Yes.
You have a right not to testify against yourself. No one can make you say anything. You have a right to speedy trial by jury, right to be represented by counsel at your jury trial, right to confront and cross-examine all witnesses called to testify against you, right to produce evidence, right to call witnesses in your favor, right to appeal this matter to higher court if you lose, and the right to require the Commonwealth to prove on a reasonable doubt that you are guilty of charges against you. Understand that by entering a guilty plea today, you give up all those rights. Now, will this be a felony plea?
Yes, Your Honor.
Okay, I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. I do not have to accept the recommendation. Prior to accepting the recommendation, I will await the pre-sentence investigation report from probation and parole. In the event that I do not accept the recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea and proceed to trial. You understand that?
Yes.
Mr. Stockton, recite the recommendation. Ma'am, listen very closely to see if this is what you agree to.
Your Honor, Ms. Jewell will plead guilty to trafficking in a controlled substance, first degree, first offense, receive a sentence of 7.5 years. She will serve 180 days. She will be then released supervised for 5 years. She'll receive credit for time served, pay court costs at the discretion of the court, and all evidence in this case will be destroyed.
Cost $155. $155, and at sentencing, I'll give you some time on that. Is that what you agreed to, ma'am?
Yes, yes, Your Honor.
Please, okay, somebody else is on here that shouldn't be on here. Are you pleading guilty? You are guilty?
I'm pleading guilty, yes.
Because you are guilty for no other reason?
Yes.
Okay, as I said previously, once you enter this plea, this could be used against you under persistent felony offender law. Do you understand that?
Yes, Your Honor.
Who has the plea documents? You have Mr. Shepard? You hold them up there. Is that your signature, ma'am, on there?
Yes, Your Honor.
I'll accept the plea subject to the pre-sentence investigation report done by probation parole, and you be back here on November 4th for sentencing, okay?
Okay.
Thank you very much.
Thank you.
Rebecca Major. Commonwealth versus Rebecca Major, 21 CR 0066. Are you Rebecca Major?
Yes, sir.
Born in 1994.
Uh-huh.
Last four digits, social security number 1335. Your day for a pretrial conference. What do we have on this?
We've never been able to meet on Miss Major because she hadn't appeared, Your Honor. So
Jesse, I think we have an agreement. I notified you
Okay.
earlier she was going to accept the previous offer made. I sent an email Tuesday and we both talked yesterday and neglected to mention it.
yeah, I guess I forgot to do it. I've had so much doing. I didn't get done with the docket till about 7 o'clock last night. So
The plea was going to be 2 years, excuse me. I believe it was 3 years probation for 5 years.
Your Honor, I would suggest that we've not done the paperwork. If we want to do the plea, we might take it up next week by Zoom. Go ahead and get the paperwork done.
Well, I can hold her off to the end of the docket. We can come back on if you want to.
Okay, we can do that. But
Miss Major, so you can go ahead and have a chance of getting out sooner. We're going to go ahead and let them do the paperwork now. I might have to reconnect later in the day with Wayne County. I'm going to be here all day long. We'll try to get back with you. Okay.
I'm in Russell County.
I'm in Russell County.
Yeah.
So,
Actually, Jesse, okay, here it is. This is one where you made a 3-year pretrial diverted for 5-year supervised offer on your offer letter.
okay. If she qualifies for diversion, I'll do that.
Yeah, so she had, in the offer letter, it says to serve 60 days. I would ask that you amend that to whatever amount she's presently
I'll do that.
served.
We'll prepare the paperwork.
Okay, thank you.
Okay, we'll prepare the documents and go through the situation when we get there, when she signs and get back over here. William Russell Purdue. William Russell Purdue.
Yes, sir.
Are you William Russell Purdue?
Yes, sir. Yes, Your Honor.
Okay, were you born in 1971?
Yes, sir.
Social Security number, last four digits, 7571.
Yes, sir.
This is 15 CR 0003, probation revocation hearing. Mr. Stockton, what do you have?
Your Honor, Mr. Purdue's on probation. I have filed a motion to revoke. He was actually indicted today on the basis for the revocation. I just asked that we enter a pen and give Mr. Shuffett the discovery on the new case, and maybe we could try to wrap it all up November the 1st.
Okay, next court date is November the 4th, but you be here on November 1st for negotiation, November 4th for your next trial date, both of them are conditions of your bond, okay?
Thanks,
Thank
sir.
you very much. Kenny Norris. Kenny Norris. Commonwealth versus Kenny Norris, 20 CR 0005. Are you Kenny Norris?
Yes, sir.
Born in 1975, last four digits social security number 7611.
Yes, sir.
Okay, we're here today on a probation revocation hearing. What does the Commonwealth have to say?
Your Honor, Mr. Norris is on for a 2-year sentence on the criminal possession of a forged instrument. He was supposed to pay $500 restitution, and since May of this year, he's paid about $250. He also had a positive meth test and a positive Suboxone test. I spoke with Mr. Shuffett, and we're proposing that he be given a 60-day sanction. He's been in about 30 days. They give the SSC time to evaluate him, and then when he get out, he could start paying the additional restitution that he owes.
What about it, Mr. Shuffett?
Mr. Norris, they're asking you serve approximately 30 more days, then be released back out on probation, pay your restitution, follow the recommendations of the SSC evaluation.
And not get revoked.
And you would not get revoked.
All right.
Okay, I'll enter that as a sanction, and we'll make sure he gets the clinicians get the information they need to get a hold of him. Okay, thank you very much. Nick Posey. Nick Posey. Are you Nick Posey?
Yes, Your Honor.
21 CR 00104. Mr. Posey, born in 1981.
Yes, Your Honor. Yeah.
Last four digits of social security number are 5606.
5606, Your Honor.
5606, excuse me. Okay, we're here for the purpose of arraignment. You have a right to remain silent. Your attorney is here. The grand jury of Clinton County returned an indictment charging you with possession of controlled substance, first degree, alcohol intoxication in a public place, and being a convicted felon in possession of a firearm. Do you understand those charges?
Yes, Your Honor.
Okay. Mr. Shuffett, do you acknowledge the identity of Mr. Posey, received the indictments by formal reading, arraignment, interplea, not guilty, reserving all pretrial motions?
Yes, Your Honor.
Okay, well, set him for the November the 1st for negotiations and November 4th for the next rule day. Okay, we have anybody there else with you in Wayne County, or is that it?
No, Your Honor, that's all.
County, excuse me. I keep on saying Wayne County.
You're fine.
Okay, well, thank you for cooperation.
Thank you, Your Honor.
You signed a reciprocal discovery order in that last case. Go to the Clinton County Jail. Billy Eminent. Billy Eminent. We have to get back down later. Billy Eminent, Billy Dean Eminent, 21 CR 0085. Are you Billy Dean Eminent? Here for a pre-trial conference. Mr. Stockton?
Custody now. If we could have a negotiation day on November the 1st and pretrial on the 4th.
November the 1st, negotiation day, and pretrial on November the 4th.
And Billy, just so you know what's going on, I made a counter offer to Mr. Stockton. He's taking that under consideration. And he and I will be discussing it, and he'll let me know where we're at, okay? And I'll be in touch with you too.
All right, thank you.
Okay, Bobby Joe Eminent.
Yes, too.
I'm Eminent. Go that way, go ahead and head that way, and I'll be on back there in a minute.
Commonwealth Kentucky versus Bobby Joe Eminent, 19 CR 0050 and 20 CR 0092. 20 CR 0092 is an arraignment. Mr. Eminent, you have a right to remain silent. The grand jury of Clinton County's returned indictment charged you with engaging in organized criminal activity, criminal possession of forged instrument, and theft of multiple taking, including cold checks. So assume that's the amount there is what? Theft by deception, including cold checks. So, but in any event, do you, Mr. Shufford, do you acknowledge Mr. Eminent's identity, receive the indictment, waive formal reading, and arraignment, enter plea of not guilty?
Yes, Your Honor.
Yeah, I will reserve taking any action on the revocation hearing on 19 CR 0050. Till we find out more about the second charge. You want to schedule him to be November 1st here for negotiation and November 4th for the next court date. Mr. Eminent, if you can reach an agreement, maybe they could roll all this into one thing for you or something like that. Okay.
Thank you.
Okay, see you then. I'm signing a reciprocal discovery order that gives him access to information the Commonwealth has. Randy Brumley.
Randy.
Commonwealth versus Randy Brumley, 18 CR 00086. Are you Randy Brumley?
Yes, sir.
Okay, we're here on a probation revocation hearing. What do you have, Mr. Stockton?
Your Honor, Mr. Brumley has a motion to revoke probation on a 3-year possession sentence. His violations this time are failing to meet with the Social Service Commission. I spoke with Mr. Shuffett and Mr. Payne, and we're asking the court if it's agreeable to do a 30-day sanction and let the SSC see him while he's in jail. And if he follows the recommendations and also he'll need to furnish proof of employment to Mr. Payne, we won't proceed with the motion to revoke. If not, then we'll.
How many days has he been in?
20.
So you just want
10 more days. They said the SSC can get down there and see him.
Okay, that sounds like a deal of the century for you there, Mr. Brumley. So what they'll do is they'll get the SSC over there and you just get a sanction, will not get revoked, and see if they can work out where you'll be more compliant. Make it easier on you and everybody else if you'll do that, okay?
Yes, Your Honor.
Okay, we'll be over in a few days and I'll sign an order to let you out, okay?
Thank you.
Okay, yeah. Stanley Ketron. Commonwealth versus Stanley Ketron, 21 CR 0097. Are you Stanley Ketron?
Yes, sir.
Okay. You're here today for sentencing. You understand that? This one had the relation. Have you had an opportunity to look at the pre-sentence investigation report done by probation and parole?
Yes.
It's substantially correct. Counselor, is any reason this gentleman should not be sentenced today?
No, Your Honor.
Upon the plea of guilty, an indictment number 21 CR 0074 for the charge of failure to maintain insurance, defendant shall pay a $1,000 fine. Upon the plea of guilty on the charge of operating a motor vehicle under the influence, he shall pay $300 fine. Upon the plea of guilty to indictment number 00084, charge of possession of controlled substance, he shall receive a sentence of 2.5 years. Or plea of guilty to information number 21 CR 0097, the charge of possession of controlled substance. Defendant shall receive a sentence of 2.5 years. The 2.5 year sentences shall run consecutively for a total of 5 years, supervised for 5 years. The defendant shall, however, receive credit for time served. He shall pay a fine as listed above and the court costs amount of what? It's DUI. It's on the wall over here, Alexa.
It's a second.
It's a second offense. $925 total. And I'll combine those other court costs.
Does that include the phone?
I'll let you pay that at $75 a month when you get out. Okay? Starting 30 days from the date that you're released. You need to meet with probation and parole.
He needs to report to Monticello Probation and Parole on 10/20 at 2:30 Central Time. And I'll send that to you.
Okay. What day of the week is 10/20? Okay, but you need to be over there next Wednesday at Monticello Probation Parole. When's he getting out? You're not gonna have him, nobody see him till then? I don't really like the idea of him being out, not being in contact with you guys.
Report in the morning at 8 a.m.
Okay, report in the morning at 8 a.m. at Wayne County Probation Parole Office, okay?
Is that Eastern or Central Time we talking about?
Everything's Eastern.
Everything over there is Eastern, so it's early, Stanley.
Yeah, that's fine.
Be better to get up, Stanley, and go over there than be coming back in at that time. You understand what I'm saying? Okay, thank you. Stanley Robert Catron. That's the same individual except with a middle name.
Take this to Brad to get him to sign it and make sure it's faxed to the Russell County Jail.
Josh Davis.
Well, he's back in there. Yeah, he's stuck right there.
Josh Davis. Commonwealth of Kentucky versus Josh Davis, 21 CR 0040. Are you Josh Davis?
Yes, sir.
Okay. Were you born in 1988?
Yes, sir.
Last 4 digits, social security number 7367.
Yes, sir.
Okay, you're here today on some charges. Y'all have an agreement worked out on this.
No, Your Honor, but I've spoken, we've got a counter offer on and if we could put that on for that negotiation conference.
It'll be November 1st negotiation conference.
Be at 1 o'clock to accommodate Mr. Stevens.
1 o'clock, 1 o'clock. And then the next court date is November the 4th. What's his bond situation?
It's been revoked. He had 2 criminal offenses while he was out, 2 different occasions.
Okay, see you November 1st, November 4th. Sure, absolutely. Matthew Denny. Okay, Commonwealth of Kentucky versus Matthew Denny, 21 CR 0055. Are you Matthew Denny?
Yes, sir.
1986.
Yeah.
Last four digits, your social security number 7916.
Yes, sir.
Okay, it looks like we have a motion for you to enter a guilty plea today. Is that correct?
Yeah.
A motion has been tendered. Are you currently under the influence of drugs or alcohol?
No, no, sir.
Is plea freely and voluntarily given?
Yeah.
Are you the same person named in indictment number 21 CR 0055?
Yes.
Is your judgment impaired today in any way?
No.
Have
No,
you
sir.
discussed this charge with your attorney? Are you satisfied with her advice?
Yes.
You have certain rights under Kentucky and the United States Constitution. Before I can accept a plea, I need to know that you understand those rights. You have a right not to testify against yourself. No one can make you say anything. Your right to speedy trial, right to be represented by counsel at your jury trial, right to confront and cross-examine all witnesses called to testify against you. Right to produce evidence, right to call witnesses in favor, have process issued to compel their attendance. You have a right to appeal this matter to higher court if you lose. You have a right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of the charges against you. You understand that by entering a plea today, you give up those rights. Now, is this a felony plea or diversion? I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. I do not have to accept their recommendation. However, prior to accepting any recommendation, I will await the pre-sentence investigation report done by probation and parole. In the event that I decide to sentence you to more than you've agreed to, you'll have a right to withdraw your plea and stand a trial. You understand that?
Yes. Yes, sir.
Now, listen very careful to the Commonwealth's recommendation, Mr. Stockton.
Your Honor, in 20 CR 47 on the charge of receiving stolen property and theft by unlawful taking, he will receive a sentence of 5 years on each of those charges. Also on plea of guilty to burglary, 3rd degree, he will receive a sentence of 5 years. All three of those 5-year sentences shall run concurrently for a total of 5 years. In 21 CR 55, charge of burglary, 3rd degree, he'll receive a sentence of 5 years. Also in theft by unlawful taking over $500, he'll receive a sentence of 5 years. Those two sentences shall run concurrently for a total of 5 years. Upon a plea of guilty to 20 CR 76, burglary 3rd degree, he'll receive a sentence of 5 years. Upon a plea of guilty to 21 CR 56, for the charge of burglary 3rd degree, the defendant shall receive a sentence of 2 years. The 5-year sentence in indictment 20 CR 47, and the 5-year sentence in indictment 21 CR 55, and the 2-year sentence in indictment number 21 CR 56 shall run consecutively for a total of 12 years. The 12-year sentence shall run concurrently with the 5-year sentence in indictment 20 CR 76 for a total of 12 years. He'll serve 6 months in jail, plus an additional 5 months home incarceration with the balance probated, 5 years supervised. While in home incarceration, the defendant shall be permitted to obtain a day shift public job, attend church, travel any doctor's visits, but shall not be permitted out of his residence from 6 p.m. to 6 a.m. He'll pay restitution in full and prior to final sentence in the amount of $7,398.89 in accordance with the attached restitution order. He'll have no contact with any of the victims' families or real property in any of the above style cases, and he'll pay court costs at the discretion of the court.
Is that what you agreed to, sir?
Yes.
You are pleading guilty because you are guilty and for no other reason. Is that correct?
Yes.
Okay. And knowing your constitutional rights, to explain to you, it's still your desire to allow me to fix the punishment according to law.
Yes.
You understand that any plea of guilty, because of this plea of guilty, any future convictions of felonies could be enhanced as far as range of penalty under persistent felony offender law. Ma'am,
Yes.
will you hold that up there, officer? Is that your signature on there?
Yep.
Okay, I'll accept the agreement order, pre-sentence investigation report done by probation and parole, and you'll be sentenced on November the 4th, okay?
All right, thank
you'll need to talk to the Commonwealth attorney about that for services or whatever, okay?
Matt's still in there too.
Manuel Fluter,
Wonder if she got rid of the board now. When she be back, and she'll make you, you know. All right. All right. You'll be all right? Yeah.
Commonwealth versus Emmanuel Fluter, 21 CR 0099. You are Emmanuel Fluter.
Yes, Your Honor.
Okay, you're here today for purpose of arraignment. The grand jury of Clinton County has returned an indictment charging you with assault in the second degree. You understand those charges?
Yes, Your Honor.
Okay, now, Mr. Shuffett, you represent Mr. Fluter for the purpose of this arraignment.
Yes, sir.
You acknowledge his identity, receipt of indictment, waive formal reading and arraignment, enter plea of not guilty, reserving all pretrial motions.
Yes.
Okay, I will go ahead and have this will be brought back up the next time any of the other associated charges are brought back up. Where we stand on this, gentleman, while we have Mr. Fluter here?
We're waiting on getting the KCPC records so we can review and furnish to Mr. Shuffett, and then we should be ready to set it back for trial.
Okay, so you want to go ahead, and docket it yourself, or you want to put it on November 4th?
I'd say put it on for November 4th. We've still not got the records from KCPC. I'm hoping we'll get them pretty soon.
Okay, that'll bring it back up. You're next due in court on November 4th, Mr. Fluter. Thank you very much. Mr. Shuffett, I'm signing a reciprocal discovery order here. There we go. Commonwealth versus Ricky Dwayne Jones. Versus Ricky Dwayne Jones, 21 CR 0032. Are you Ricky Dwayne Jones?
Sir.
You're here today for a pretrial. You have your appointed attorney cannot be present today.
That's correct.
So they have a stand-in of today, but we will schedule you to meet with your new attorney on November 1st and back in court on November 4th. She'll be in contact with you. What's her name again? Candace Hill is your attorney. She'll be contacting you there to discuss your case with you, negotiate with the Commonwealth on November 1st and have your next court date on November 4th, okay?
John?
Yes, sir.
Hey, is there any way that I could ask for ankle monitor?
Well, what you need to do is you need to talk to your attorney. And since we missed the date here, Mr. Stockton could very well review that with the attorney since there's been a change. And if they can reach an agreement, then we'll do something on it. If they can't, we'll address it the first thing on November 4th, okay?
All right, thank you, Stockton.
Very much, yeah. Commonwealth versus Lucas Pettinger. Commonwealth versus Lucas Pettinger. Are you Lucas Pettinger?
Yes, I am.
This is 21 CR 0080. You're here today for the purpose of sentencing. Mr. Pettinger, have you had an opportunity to look at the pre-sentence investigation report? Is it substantially correct?
Yes, it is.
Mr. Shuffett, is there any reason why this gentleman should not be sentenced today?
No, Your Honor.
Okay. Upon a plea of guilty to tampering with fiscal evidence, the defendant, Lucas Pettinger, shall receive a sentence of 1 year. The defendant shall pay a fine and court costs, and the court costs are $155. And all the contraband shall be destroyed. Okay? I'll allow you to pay the fine, $30 a month. First payment due in 30 days after you get out. Yes, go ahead. You have something to say?
No, I don't do it.
Okay, thank you very much. Bobby Ray Phillips. Commonwealth Attorney versus Bobby Ray Phillips, 20 CR 0054. Are you Bobby Ray Phillips?
Yes, Your Honor.
You born in 1968?
Yes, Your Honor.
Last four digits of social security number 5121?
Yeah.
Okay. You're here today on a probation revocation hearing. What does the Commonwealth have to say?
Your Honor, Mr. Phillips is on probation on a 12-year sentence. Recently, he allegedly shot Michael Winningham as a convicted felon possessing a .410 shotgun. My understanding is that he's going to stipulate that he was charged with that offense.
You also have 20 CR 0055.
Yeah.
And 20 CR 009.
Your Honor, that's correct. We would stipulate that he's been charged with some new offenses, including the ones mentioned by Mr. Stockton.
Has he been indicted yet here, or
You should be receiving the indictments today.
you just want to wait on these things to November 4th, put a pin on him?
We can, but if we do that, we'll be waiting for a trial, I guess, till we try him. But he had the possession of a firearm, a convicted felon. I mean, he can always have the choice of evils defense, I guess. But I don't think there's any dispute he had the shotgun.
Okay, well, we'll just go ahead and revoke then. And when we return the indictment, we'll see him on the 4th.
Yeah.
Thank you very much. Ricky Poor. Commonwealth versus Ricky Lance Poor, 20 CR 0057. Are you Ricky Poor?
Yes, sir.
You're here on a revocation hearing. You're represented by Mr. Sheffett. Mr. Stockton, what do you have on this case?
Your Honor, Mr. Poor was in drug court and he was terminated from drug court and then he left the state and he finally came back from Tennessee and we're asking that he be revoked. It's my understanding he's going to stipulate that he was terminated from drug court.
Is that correct, Mr. Sheffett?
Yes, Your Honor.
Okay, we'll go ahead and do revocation. I hope he'll serve his sentence as previously given. Commonwealth versus Mickey Shelton. Commonwealth versus Mickey Shelton, 20 CR 0084. Are you Mickey Shelton?
Yes, I am.
Okay, Mr. Shelton, were you born in 1970?
Yes, I am.
Last four digits, social security number is 7583.
Yes, sir.
Today for sentencing, have you had an opportunity to look at the pre-sentence investigation report done by probation and parole?
I did.
Counselor, is there any reason why this gentleman should not be sentenced?
No, Your Honor.
On a plea of guilty to assault third, the defendant shall receive 5 years, serve 418 days with a balance probated for 5 years, supervised. Have no contact with the victim or the victim's family. He shall be released today at final sentencing. He shall keep a job. Pay corporate the amount of $155. Need some time to pay that.
How much?
155. You need some time to pay it.
Yes, sir.
Okay, I'll let you pay it $30 a month till it gets paid, and I'll give you 30 days from today to make your first payment so you can get on your feet a little bit, okay?
Appreciate you.
Okay.
Judge, you need to report to Monticello probation and parole in the morning.
Okay. you need to
He's
go-
not going to be released. He's got a Tennessee holder that he's going to have to go take care of, so he's not going to be released today, but
As soon as he's released, he needs to report straight to Monticello.
As soon as he's released, he needs to go straight to probation and parole Monticello office, okay?
Yes, sir.
Okay, thank you very much. Eric Ray Story. Eric Ray Story. The last shall be first, right?
Thank you.
Are you Eric Ray Story?
Yes.
Born in 1973?
Yes, sir.
Last four digits, your social security number are 3700.
Yes, sir.
You're here today for sentencing. Have you had an opportunity to look at the pre-sentence investigation report done by probation and parole?
Yes, sir.
Is it substantially correct?
Yes.
Counselor, is there any reason why this gentleman shouldn't be sentenced today?
explain something.
Sure, go ahead.
You know, we left here last time, he was out on bond. And he was gonna have 39 additional days. So I anticipate
You need to speak up a little bit.
when we left, he was on bond. I anticipate he sentenced today. At 30, we're supposed to do 180 days, credit for 141. He's gonna have 39 more days to serve. So that would have given me time to wait for 30 days to ask the court for shock. Now then, he's gonna have to end up serving some more days unless the court does something else. It's not the Commonwealth's fault. It's his own fault. Because he didn't show up for his PSI. So I cannot, as I understand the law, if I can't ask for shock for 30 more days from today.
Nothing I can do about that.
Nothing you can do about it, but I just want him to understand. It's not the prosecutor's fault, it's not the court's fault, it's not my fault. But he's going to end up being in at least 199 days before I can file for shock. So I just want you to know that he's going to have to serve like 20-something more days.
Okay.
It's because of his action. I just want him to understand that it's not the court's fault,
Okay.
not the Commonwealth's fault, not my fault.
Okay,
So I just wanted to thank you for giving me the opportunity. Your Honor.
okay,
I don't know any reason not to sentence him.
okay. On a plea of guilty to trafficking, for first offense, she shall receive a sentence of 7.5 years to serve a total of 180 days, or subject. The defendant shall receive credit for time served. And the Commonwealth agrees, sir, to go ahead as soon as possible, as soon as you're eligible for shock probation, to agree to shock probation. Now, what we might very well do, Mr. Stockton, if that's the case, when that first day comes up, we might not wait until the next rule day.
That's fine. If he wants to submit a read order, I'll sign it.
Yeah, what we'll do, Mr. Stone, Mr. Story, since this has happened, as soon as you're eligible, we won't wait till the next rule day. They'll go ahead and do it, and to try to help you and accommodate you on this thing, I'll go ahead and sign the order then, okay?
Okay.
Okay, thank you very much.
30 days on Saturday. Your Honor.
Okay, it falls on a Saturday.
Mr. Stockton, I know.
Well, I mean, if you get it over, we can sign electronically by Saturday. I don't know,
Okay,
you know.
I'll do my best.
Okay,
Thank you.
okay, is there anything else in the Clinton County Jail? And we got one other case that we passed over. Thank you, Clinton County Jail. I guess Rebecca Major back up in Russell County. Have we got the paperwork over there to her yet?
Yeah, it was sent to Russell County by our office or the clerk's office.
Okay, I guess we need to get them back online.
I'm trying to talk to
They have to do it.
Do what?
We went over the paperwork, but I want to make sure she's clear on everything. I've got her on the phone right now.
Okay. Here, let's go into recess here.
Your Honor, could we take up the Tommy Claiborne case?
And I wasn't able to get with Rotor to get him on. I figured you wanted to just do it. So.
Okay, go ahead.
Your Honor, this is a continuance of our motion for shock probation on Tommy. He's the one that's got liver failure, and his condition is not getting any better. I don't know what Mr. Stockton's current position is on the matter.
Looks like he's coming out here.
I'm not sure he's.
I think he is as we continue.
I had it as overruled. I don't know. Maybe Mr. Stockton.
I read the records of Mr. Cross Furnace. And he has hepatitis and he has a liver lesion. But they said there was nothing, it's just a chronic condition, they just need to keep on. So I don't see anything to keep, it needs to be released.
Okay,
In all fairness, he's not, he's broken where you can't get any illegal substances, he probably won't prolong his life.
He's not going to get any better.
well,
When he'll get out.
that's probably true about all of us.
That's true.
Okay, thank you for bringing it to my attention.
Pardon?
Thank you for bringing it to our attention.
And I'll send you an overground motion.
Or you said we want to deny the motion, so.
I've got one here. I've got one.
Yeah, I guess we'll go to recess now.
Recess.
Yeah. Mr. Cross, this is bound to have been a banner year for y'all down there in Gatlinburg.
Oh, it's crazy.
I was down there for that Gospel Quartet convention, and it was unbelievable. People were even banging up there to this condo I lived to see if they had extra days. They couldn't find any hotel rooms anywhere.
We're full through November.
That's wonderful.
We're just, and it's just-
Well, I mean, it helps make up for a rough year before.
well, honestly, with that PIP thing they did and all, that last year wasn't that bad. People came back so strong, but
Yeah.
we're just blessed beyond,
That's
beyond
good.
belief.
I tell you what, everybody thought that Gatlinburg going wet and blooming out with, Pigeon Forge, but I think they actually complement each other. It gives people more choices to think through back and forth.
Pigeon Forge is a family place. Gatlinburg is a place for couples and people that like to walk around and do things. And more, and people go to the park. Pigeon Forge, people want to go to it's the carnival, it's the service. is what it
I'd
is.
much rather be out.
Yeah.
Well, I'll tell you what, they've got that convention center rolling now.
They're-
That new parking up on the hill now, and that causeway they got over there.
And they've got real good athletic facilities now in both places
Yeah.
for youth.
I tell you, it's a
I think
shame
we're
to
going to
have,
the softball tournament down there.
yeah, it's a shame to have parking up on top of that hill there because it's got a tremendous view up there. What you got?
Judge, there was the opening case that got us off on a great start this morning. I think the stairs, we were gonna have an in-camera
Oh, yeah.
Yeah,
discussion.
She was the only one I didn't have down. I thought I had missed her.
yeah. Well, grab Mr. Stockton there.
Well, it's really, I can't really disclose stuff. and-
Well, we're off the
It's
record.
the
Just tell me
call.
what the problem is.
Let me get us off. We're not on.
Let's go off the record. Wait a second.
Let me just mute you.
And I need to ask bailiffs or law enforcement. I need to ask them to.
Yeah, if y'all
Area code 509-907-7453. Area code 509-907-7453. Female subject, Wendy John. Reference to a Hazen housing.
I'm sorry, Neil, did you say yes or no on that receipt?
I've got, yeah, the mom's already got. Kendra Crowley is ROR code. Does this print to that? No, I'm not set up on that. Okay. Oh, shit. Jose Hernandez is a surety bond. Okay.
I'll print them.
Okay.
Judge is muted. There you go.
Okay, Ms. Major, will you hit that button there and turn on? There you go. A motion's been tendered, Ms. Major, that says you wish to enter a plea. Is that correct? Are you currently under the influence of drugs or alcohol? You're gonna have to speak up a little now.
No, sir.
Okay. Is this plea freely and voluntarily entered?
Yes.
Okay. State your full name and your date of birth.
Rebecca Kathleen Major, and January the 11th, 1994.
Is your judgment impaired today in any way?
No.
Okay. Have you had time to review this matter with your attorney, and are you satisfied with his advice?
Yeah, we talked on it the other day.
Okay. You have certain rights under the Kentucky and United States Constitution. Before I can accept a plea, I need to know that you fully understand those rights. You have the right not to testify against yourself. No one can make you say anything. You have a right to speedy trial by jury, the right to be represented by counsel at your jury trial, the right to confront and cross-examine all witnesses called to testify against you, the right to produce evidence, the right to call witnesses in your favor, the right to appeal this matter to higher court if you lose, and the right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of the charges against you. You understand by entering a guilty plea in this case, you give up those rights. Now, Mr. Commonwealth Attorney, is this a diversion or is this a felony plea?
Diversion, Your Honor.
Okay. You're requesting that I sign an order granting a pretrial diversion. That means that if you successfully complete the pretrial diversion, the case will be dismissed, pretrial diverted, and you get it expunged. However, if you violate the terms of pretrial diversion, you're brought back in front of the court. I revoke your pretrial diversion. I'll have a pre-sentence investigation report done by probation and parole. You'd be a convicted felon, and that could be used against you in the future if you had another felony. Do you understand that?
Yes, sir.
Okay, I'll listen very carefully now. Mr. Stockton, go over and see if this is what you agreed to.
Your Honor, Ms. Major would plead guilty to possession of a controlled substance first degree, receive a sentence of 3 years, pretrial diverted for 5 years supervised. She would be referred to the Social Service Commission following all recommendations, receive credit for time served, be released upon entry of the plea, obtain and maintain gainful employment or do 30 hours community service a week, pay court costs at the discretion of the court, and all evidence in this case would be destroyed.
Is that what you agreed to?
Yes, sir.
When should she meet with probation and parole?
Office in the morning at 8.
You're gonna get out of jail today if that's all right. Okay, you be at the probation and parole office in Monticello at 8 a.m. their time, okay, in the morning, just to get your conditions. Now, and what are the court costs in this? There wasn't a DUI or anything in this? $155 court cost. You need some time to pay that?
Yes.
Okay, I'll give you, you can pay it $30 a month, the first payment being made 30 days from today, okay? Okay, good luck to you. That concludes this circuit court. We'll now go into recess for 10 minutes until we go into child support. Thank you very much. Thank you, Russell County. Hey, you go to Athens?
No, actually, it's one of Athens. Brad, he asked for tickets. His son's a big Georgia fan, and he asked for tickets. back in the summer, so I got him thinking.
I'm trying to get somebody to tell me it's a bad idea, because it wouldn't take much for me to fly down there. I had a guy call me last night, offered me to fly me down there from Lexington. I thought, well, hell, by the time I drive 2 hours to Lexington.
I drive.
Yeah. I've been down there before. It's a great place. What do you think about it?
I think we'll go with the spread and I'll.
Yeah, the spread was 23 and it went out to 21 and a half, didn't it?
That spread is ridiculous.
Well, I don't know. They beat the hell out of a lot of people this year.
They're good. They're good.
Let me tell you, Oxidine going out for the year is a bad thing. Will our big nose guard be back up? Is he gone for good too?
No, he'll be back. Maybe Mississippi State's the same.
You know, that Oxidine was playing. He was wild.
He was
The best.
players of the week.
Yeah. And so we also don't have Ali, right?
Yeah, I don't think he'll be back.
Yeah, he's not gonna be back for this game for sure.
So then they get the bye week.
He healed up, son.
Build up, so.
What if they would go down there and beat Georgia though?
Then I think the playoffs is legitimately.
Yeah, but now here's the thing about it though.
Still got to beat Tennessee.
Yeah, I was gonna say, you got Tennessee.
Mississippi State, we never. play.
Well, I'm gonna tell you what, Mississippi State can bust you.
They could be ranked #1 in Tennessee dead last and go to Knoxville and get the.
Same way Mississippi State, they never play well. I went down there 2 years ago, that's the worst trip I've ever had.
I think Knoxville, they're gonna go in and they're gonna carry it off and end up.
You know, they won't take it for granted going to Knoxville. I mean, they watch Tennessee play.
I bring you greetings from the Honorable from Texas, from the Honorable Darrell Russell Coffee.
When'd you talk to him?
About 5 minutes ago.
Is he doing anything but invest in land and stuff or what?
He's made a whole lot of money.
Oh, he has. Well, he's a money maker. Hell, there wouldn't nobody else understood that, what he did with that Maribone Forest over there. I didn't think he made a fortune with that.
He did good. He's pretty clever. He learned from his daddy, he learned a little from you.
Well, let me tell you something he did to do this, this pre-lock stuff, this DUI stuff. They've made millions off of that.
And I'm against it.
I'm again, it would never pass five minutes. It's just a extra
racket.
tax.
It's a racket.
No doubt about it. It's just like these slot machines. Now, you know, Churchill Downs has sold Arlington Racetrack to the Bears and going to tear the third best racetrack in America down.
Really?
They're gonna level it. They don't give a damn about horse racing. They run this state. Don't let anybody kid you, they run this state. Margie Duval sent me a letter. She's read this Wilson article about Poston. And I was upset about it and everything. I said, well, Margie, she said she still loved me and respected me. I said, well, I said, just continues a pattern throughout my career of being abused by the Career Journal, the Herald Leader, demonized. I said, it doesn't matter. But if they consider the thing, if they look at the things that I've done for Louis, they never will. I don't understand it.
You never get any credit for it, not one of them.
Yeah. Not
Got
from
hard
that.
for your name.
But you know, I didn't think those articles were that bad, except it held me up to scorn, and I'm a victim. You know, I didn't. They said, well, they didn't interview me on the record. Well, I don't know how many people that are victims have been interviewed on the record, recording their statement. You know,
I don't. Wilson is the one guy up there. I've never had any dealings with him to speak of.
well, he drank out of the same trough that all them bastards did. It's an amazing thing to me, but I don't see how they expect. We deal with a lot of things. I mean, lawyers deal with a lot of dangerous people. I tell you, sometimes I think defense lawyers are more dangerous than prosecutors.
I'm trying to agree.
Because people tell the shit that they don't tell anybody. You know what I mean?
That's true. That's true.
Yeah, and they don't trust anybody, so they feel like you sold them out and all that kind of stuff. But, you know, you just, and it's that I got in an argument with that guy in a bar. Well, I didn't get any argument with him. I just, me and my cousin, Dr. Gary Davis, walked in there. I wasn't even a patron. He comes in there, come bum rushed me over there. I said, let me give you a big hug here. Give us a grab. I said, no, I'm just saying,
I think he's drunk.
he's doped.
Doping.
Yeah, he's doped all the time.
See, I-
But hell, here's the thing about it, David. He was out on bond for 270, on a federal bond and a state bond when he costed me. He's probably not even entitled to bond if they didn't want to give him when he violated terms of the bond. But he had two he had a special judge that was sitting in because I had recused myself from his drug case over there. I was that damn Mary Todd. I didn't call her. She called me when he got arrested in the Fed. She called me in the middle of the night when they arrested him on his nights. And then she went down there to the lake, and those people, I was gonna fix a case. I mean, what an idiot, you know? So, I mean, you think a judge cannot report that? You know, I mean, would you want to be, you want to be on the record if somebody talk like that? What's the weather gonna be like this weekend?
60s, might rain tomorrow evening, but the highs in mid-70s and mid-60s and good weather on Saturday.
There'll be 1 million damn people here on Saturday.
It'll be huge. Yeah, and I'm looking for a good crowd tomorrow night for that Jakku.
I don't know who that is.
He won. the
American
Voice.
Idol or something.
The Voice.
The Voice, same thing.
He's out cooking. They say pretty good. I don't know. There'll be tons of people. You need to go hear that Winningham thing Saturday. When is that?
Where's that gonna be at?
It's gonna be at the Fellowship Hall, First Baptist, going on Cumberland Street. It's 12, 2, and 4 o'clock. And the lady that's writing the Winningham book, and you know what the Winningham affair is?
I did at one time, but tell me.
The Winningham affair is in 1933. The sheriff and the deputy sheriff, his son of Pickett County, were killed up at Stearns Coal and Lumber logging camps. Their brother was a sheriff of Clinton County. A group of people from primarily from Clinton and Pickett County went to Huntsville, Tennessee, where the assailant was incarcerated, allegedly broke him and another man out of custody there, took them out and killed them both. And then the rest of the story is Sheriff of Clinton County died in a gun battle about 2 months later, and several of the people that went on that excursion, that ill-fated excursion, died very soon thereafter. It's a terrible story. It's a terrible, terrible story. It's been 88 years ago, but people wouldn't talk about it in Clinton County. My dad would not talk about it. Nobody would talk about it. Dad didn't go. He said Willie never asked him to go, but it's a fascinating story. Oh, it'll make your hair curl. It's awful, but it's history. Yeah. So I recommend anybody to go.
There's so much more connection between Clinton County and Tennessee than there is Cumberland County in Tennessee.
Well, we're so close.
Well, we're, closer than we are.
No, we're 12 miles.
I know, but the county, I'm saying,
Well,
the county, excuse me. But the hell of it is over there, the only people that know anybody in Tennessee over there is people that live down in Ashland or those communities. I never know about. I don't know 5 people in Slime, Tennessee.
There's one difference, I think, the terrain, when you start at Old Willow Grove or Lilydale and go east until you get up toward Bald Rock, and Wolf River was wound in and around, and there was a lot of farmland in there, and a lot of people lived on one side or other of the river. And there's crosses in Pickett County and crosses over here. There's a lot of Clinton County people buried over there, and vice versa.
I talked to Phil Cross down there at the Gospel Quartet Convention. Reintroduced myself. I'd met him before. He said, well, you're home, folks. He's a very talented person.
I've never met him. I heard he's very, very good.
He's distantly related to you.
Yeah. Oh, yeah.
Yeah.
He's
Claims he is.
Stanley's bunch.
Yeah. But now his group is called Poet Voices. And he's written some songs that you recognize, some big gospel songs.
Yeah, sure.
Well, it's time to start up again. I know everybody's. Okay. I got a docket for this. Okay, let's go on the record here on the child support docket. First case is Cabinet against Colt Alley.
Your Honor, we just spoke with him and he is headed down to the child support office as soon as we head out of here to sign it.
Paso.
Yeah.
Graham versus Graham.
Judge, we have an agreed order on that.
Cabinet versus Harper.
Your Honor, in this case, Mr. Harper, ordered to pay $2.99 a month for arrears, about $23.93.81. We're asking to have $700 paid, November the 3rd.
Okay, sounds reasonable. Cabinet versus Jones, is that correct?
Yes, sir. We have a big order in that case. That's your next one.
Cabinet versus Owens.
We have a great order in that case. That's it from us.
Well, y'all aren't doing much, I tell you. Okay, we're off the record. I bought some basketball tickets. Such basketball tickets. Now, you got season tickets. You're in the front row, upper arena or
Well,
something.
I qualified for an upgrade. Now I got some rollers and kids.
Yeah. How much you have paid for yours, the ticket?
They just upgraded it on Monday. I can't remember the exact amount. I'll do it on a 5-month payment plan.
Well, I mean, how much a year is?
It was the first year I've had these. So. Yeah, because I just got upgraded, so like that. No, I keep the UK facilities out. It is. So it's 48.
See, that's what I'm buying these for.
Is it the light blue is what those are, or the light green? That gives you the amount for each, so you're getting them for face value.
Yeah, I tell you where these are. One of them is a 17.
Okay.
And one of them is in 43.
So yeah, you're getting them for face value. You know, I was a little hesitant to leave that front row upper level because that was a good view.
I'd rather be up there. What they cost up there?
The K-Phone went in half, it was 500 instead of 1,000.
Shit, I'd really have that too.
I was hesitant.
But if you decide to market them, being in the lower arena, it takes the price up 2 games. But that's not a bargain for tickets anyway, because you can't piece them out and sell them for that, can you? Because they got so many shit games.
Oh, it's a real often season.
Yeah.
Everything's neutral court. Everything's neutral. Any game a person can go up there pretty much get it.
Yeah.
Because they're like, so horrible. And that's the knock I have on Cal. You know, back in the 70s and 80s, you had that rub, you had Kansas and Ralph on. Younger, they break up the home up there and play. Syracuse used to come there.
Of course, they get punished when they do that at the end of the year, but let me tell you something. I see a lot of people, I've got that condo up in Lexington now, I'm up there a lot of weekends. Cal support's about a 1/2 inch deep. I tell you, them taking that knee and stuff out there, it hurt me. Don't you think it did?
And I think that's why everybody's getting these loans.
Yeah.
They just moved the loans. Just moved the loans. Jacqueline Saunders. We're just, I don't think everybody's renewed it there. It's just, I don't think people's is anyways.
Well, these people are selling these so they can keep, they don't want, to lose it.
How are you feeling?
I'm doing okay. I'm getting my medicine adjusted back.
What's been wrong with you?
I've been receiving medicine for about 25 years, and just here September 11th and September 26th, I had two. So
Seizures.
yeah, I had one down here at the office, and I had one jogging down on Burkesville Road. Woke up on the side of the road on Burkesville Road, and I've been watching that. You know, of course, that's no driving for 90 days when you have. So, well, not much. So I'm having to depend on a lot of people to call me around. I think it was a medication issue. They changed it last year, month, so I can figure out why they changed it. Well, I think something broke.
Right.
Yeah, they changed it after EEG. It didn't work.
Had you, how old were you when you had your first seizure?
Freshman in college.
I've had one seizure in my life. And I had it when I was in high school, playing baseball. And we were over in the dugout, and that's when we had chicken wire. You know, they used to use chicken wire. And I got my hands in that chicken wire and went down, and it was just like a surreal experience. I kind of knew what was going on. You know what I mean? My teeth tightened up, and I was going away.
I can show you pictures. My tongue did all chewed off pieces.
And I could not believe it. I thought, well, hell, am I having a heart attack? Because nothing feels like it. It's and my eyes were flittering and the black lights going on. And they said it was dehydration. I never had another one, you know.
I had a friend, she had brain cancer, and she didn't know that it had come back, and she had a seizure while she was up on a rope course. Way up high, and had to just stand, and she knew she had it before with her cancer, and had to just stand and hold on and let that seizure pass while she was up standing on a rope course.
The hell of it is you don't know how long it's going to take to pass.
Right. And with mine, I have no warning. I mean, there's just none. The first one I had up here at the office on the 11th. Luckily, I was on the speakerphone with Angela from the office, and she knew what was going on. And she had somebody pick her up. She was out jogging and bring her up there, but they just hit you. I mean, I don't have any warning.
What did they do? They give you a shot, bring it back?
Just let it pass. I mean, here's how quickly this hit up there. I'll show it to you, like, because there's a security camera. I just walk back in the office and I freeze up. Just go straight back to the ground. I don't remember any of that. I remember none of it.
Lucky you didn't hit your head there.
Yeah. And when Angela got up there, I was just walking around out in the parking lot. I don't remember any of that either. You do. That tongue ain't no ruler. That's the worst part. That's the worst part. It's the worst. But I think it was just a medication issue. I think it's fine, but I can't drive now. So I don't want to right now.
No.
Just have to make sure I have a ride in my ball games. That's the main thing.
Well, you cut me a ticket too. I might drive.
He loves having the chauffeur.
Yeah.
I think he's got a new driver.
There'll be no shortage.
No shortage of drivers.
It was one of the most exciting games.
I was telling you, we're supposed to play tomorrow or Saturday in the softball tournament in Campbellsville. Hartford is. And BJ's like, we can't go to that tournament. He's like, UK plays.
3 o'clock.
He's like, we can't be going to Campbellsville.
These softball tournaments last.
Luckily,
These
this is.
people don't have a life. They do
Hey,
nothing.
he does it too.
I mean, whoever's scheduling these people done it, they don't have a life.
Luckily, it's just Harper with the Cumberland County team. So 8U usually wraps up pretty early in the day. I heard they had to pick someone out of the monster mash.
See, I missed that because of the football game.
It was after we left. I think it might have been the 14U, but Chris Tweedy had to throw someone out of the park apparently. Yeah, I didn't see you there. You weren't there.
Yeah, I was at the football game. Harley skipped too, because she loves it as much as I do.
Well, we didn't. Harper played with the Burkesville team and Aubrey played with the Salina team, so.
You know, you don't realize how much difference that the crowd makes. It's hard to get out of there right now with that parking. You got a parking pass? Where you at, blue or, you see, I'm in orange. And, I get out of there, but, cause I want to go back down Tate's Creek over, I live over on that side. And so I've got to come back and wait till I get back over to the blue lot and take a left, and go down. Now they got Cooper Drive cut off all the time, so you got to go down.
My crowd calls all those false starts and it's full.
Oh, I no doubt about it. So well, you don't have to fight the crowd either, so.
Well, we had 25,000 in Indiana, set a record.
Well, it should have beat them.
Oh, yeah, no question about it.
That's right. It's, I mean, they got the talent down there.
That's what we're doing. You know, stupid, too many minutes.
Going to Division I was one of the most brilliant things ever happened. I remember Ransdale called and said, "What do you think about this? What do you think about this?" Because he's afraid everybody, you know, all the politicians give him. I said, "Well, hell, that's the smartest move I ever seen. It takes all your programs up. It takes your basketball program up, gets you visibility." Oh, hell. Well, it's Division I. It's big time, you know. Well, compare what's going on there to what's going on at Eastern now. Well, I can't understand why they didn't go Division I. They've got the best football history around. We got 10 minutes to go.
No. It's, we have domestic at 1:15. Congratulations, Matt.
Thank you. Yeah. I don't know, I'll be too old to get started.
How old are you?
40, just turned 40.
BJ was 38 when we had Trey.
Well, we just announced it 3 or 4 days ago. No. It's due in April. Yeah. So I got a little time to prepare.
This moves.
Oh, yeah, that's what it was.
Okay, on the moon's one, she's one that dismissed, so he probably. Yeah. So we were talking about. Yes. So he probably won't be here, but.
There's an order with the.
For dismissing. Okay,
I don't think she's been served on this case.
okay, it's.
He only gets her, but I don't know that she's been served.
We didn't sign this.
They've got a civil case pending, a custody case. That's the reason they put it on.
Okay. Did one of the districts?
It might be on the docket today too, to see how.
It is, both of them are on, that's why I kept it. Did the district judge hear it?
They never have. It was on for there and they put circuit court.
Okay. Okay.
What do you think, Sam? It's unbelievable. I mean, they were waiting outside the office. I was turning people down. We had all day civil trains.
Well, I followed the number of cases every year. I believe somewhere. I checked also.
He's heard the EPO, I thought. Yeah. Yes.
Okay, let's go on the record here today, right now. We have the case of Catherine versus Anderson. Domestic interpersonal.
There's a, this is the domestic portion of it. There's also a custody portion.
Got the other set to 130.
I didn't see the file with him. I didn't know. So maybe we could hold. Strongest spirit, thunderstorms coming in.
We'll wrap her.
This is Billy Robert Catherine versus Ashley Green Anderson. Where is she?
Your Honor,
She was served.
She was served with just before, wasn't she?
Charlotte told me that he, at this time, she told us folks on the phone.
How are you involved in this?
Involved in the custody case and helping Mr. Cathy with this.
Looks like Judge Lawson signed the EPO and then they realized it was a custody action file, and so they sent it on up to us.
Let's see if they have any notice.
There's no notice sent out because it was originally heard on September 14th was the notice. And on that day, the way I understand it, Judge Latham had them on the phone or on Zoom
I wasn't there, but that's what really is.
and rescheduled it for today.
Ashley Anderson, from Cumberland County, is this way. First.
Okay, well, we'll just pass over to that.
He's on the way.
Just have a seat back there somewhere. Ashley Moons versus Timothy Moons.
Your Honor, entered a brief order dismissing the force. I don't know if it's been signed.
We're waiting
And
for
first
today.
verified that the Herald.
There's a motion to amend.
Hello. It's Ashley Moon versus Timothy Moons. There's a motion to amend a prior protective order. And it says, I want to drop the EPO previously filed to pursue counseling in hopes to reconcile. Is that what you want to do? Okay, now you're not under any coercion or anything like that. Well, the reason I had y'all up here personally here today is because I had no doubt of what was going on, but there could be a certain situation where someone was being unduly influenced. So for the protection of the parties, I require them to come back in. I'm all about reconciliation. I'm all about anger management. I'm all about people solving their problems. But you understand it's my obligation to protect people too when they come back in. So that's absolutely what you want to do. Okay, well, we'll sign it today. And there's also in the civil docket, you said there was an agreed order to be signed dismissing that. You want that, both of you want that signed? Okay, okay, well, good luck to both of you. Okay. Okay, okay, take it easy. Yeah, no problem. Okay, now, take a 5-minute break until the civil docket starts.
They're trying to take my computer.
You what?
AOC is trying to take my computer.
Why?
They don't want me to have a desktop in my office and a laptop. They said I have to only use this one. I told them, I was like, you know, this is used in court a lot for Zoom. I still need access to my computer.
Yeah. Who are you talking to?
Somebody emailed me from AOC.
Well, you need to make sure that I send an email from me to the director. She'll take care of it. Just make it for me. I mean, not only do we get the lowest number of personnel anybody in the world now.
Well, that's why I just told her, I was like, I'm his only employee, but we don't allow him extra.
It's not even really.
She said, unfortunately, our policies only allow one device per user.
Yeah, well,
They've tried to do this before, and I always dodge them every time. They won't give it to me. Now they're telling me it's creating a security threat on the network, because it's not up to date.
yeah, right. Well, she's not. Is this, this first case on the docket's one of the girls on the way over here? Right?
Yes. Is it 1:15? Ralph just got here for the actually. Let's get to it.
Yeah, I took pains to go over it with her. It was on for 1:15. I didn't know you were coming. I'm sorry.
You know, all those Southwest Flight Consolation. They were coming back from Orlando and their flight got canceled. And they had to fly to Dallas and spend the night in Dallas and then catch a plane to Nashville the next day. That's the only way they could get back. They're all scheduled at 1:30 if you want to skip over the first one.
Okay, let's start the docket. Discover Bank versus Jenny Coffee. File that. You give me the file. Okay. Services property, check service today, right? Okay, you want this mailed to you? You want to get a stamped copy of it today? Okay, no problem.
The next one's passed generally.
Dalton versus Dalton, passed generally. Okay. Independent Capital Holdings versus Shirley Fight and others.
I think it's just my motion for warning order report, warning order fee, Your Honor.
I don't know, we'll see. They won't get signed if you get it.
Do one at a time to matter.
Here, let me get it. We'll just get it later. Guffey versus Guffey.
BRC.
Central Domestic Relations Commission. Huff and others versus Johnson and others versus Huff.
We have somebody appearing to use them.
Hartwood Acres, the plaintiff.
Okay, someone's appearing by Zoom here on this, is that right?
Yes, Your Honor. Good afternoon. John Jesse on behalf of defendant Bustler, Willie Bustler.
Okay, what do you guys got today?
This is a plaintiff's motion to file an amendment complaint to add a claim for declaratory relief. The two of the defendants agreed that they would do an agreed order, but defendant Geico is objecting. Essentially, they want to argue the merits of the case, the declaratory judgment action that we seek to add. And we want that too, but it's kind of putting the cart before the horse. We just want to amend the complaint today and then worry about briefing the action.
Which ensured Mr. Higgins' client, Johnson was badly hurt in an automobile accident. He made a claim not only against the court fees, but he made a claim against Geico under Tennessee policy, which provides uninsured and underinsured as a point of coverage. In Tennessee policy, your policy is limited, you can't stack under coverage. And secondly, in Tennessee, you get an offset for the amount of coverage that's provided by the court fees. In this case, the court fees are $5,000. Johnson had a policy that was named insured under the policy, provided $100,000. Now we offer tendered a check for the $75,000 we think we get. That'd be 100 minus the 25 for the court fee. It's been rejected, and under the claim that there is some kind of question. Well, first of all, it's admitted in the amended complaint and in the original complaint that Mr. Johnson is and was at all times relevant.
Okay, before we argue anything, let's go back to what he wants to do. He wants to amend. Let's stick to the amending. Why shouldn't it be amended?
Well, first of all, there is case law. Like, First National Bank. The amendment itself is futile. The court has the discretion to deny. And in this case, never been a response to our substantive market. This is governing.
Okay, what do you say about that?
It's not time to argue.
Well, it's time for you to argue to me because I'm asking you about it. What do you have to say about it?
I was just responding to his argument, Your Honor, but I essentially argue it's going to be the power of public policy. What's that anti-stacking provision in consent of court? So we believe that the coverage is going to stack. Could I be wrong? Potentially. I've got a number of cases that I'm ready to cite and file a brief on the merits of the issue, but you know, CR 15 is clear. The permission to amend is mandatory when justice requires it.
Well, I'm going to allow you to amend the complaint because I just want to hear the arguments. You might very well be correct on the thing. I don't think any harm will be done to you by the amendment.
I would just ask that we use terms for the submission of declaratory judgment. In fact, the statute itself and the rules say it's supposed to be given priority. It's supposed to be in a manner. So I would hope that I would look at follow with the anticipation of being heard next month.
Works for me.
Works for me if it works for you guys. I mean, obviously there is an issue that needs to be resolved, kind of a conflicts sort of issue. And so let's just hone in on that to see if that policy, diminishes someone to make a recovery under Kentucky law if they've got out-of-state policy. Sure, there's a lot of case law on it. I don't know. I just don't do that much. Okay. Thank y'all very much. I'll sign it. Thank you. Yeah. Okay. Kelsey versus Kelsey. Make sure that order's here. I'll sign it.
Mr. Cross. Mr. Cross, I found the order.
On the warrant mark?
Yes.
Wonderful. I'm much more advanced than I thought.
Yeah, it was stapled to the motion.
last
He's
case.
This is from the last one.
Kelsey versus Kelsey.
Yes, we call them motion for default, roll call response. Then I'll call them both of them, because he didn't disagree with it at all.
What's relief you seek? What relief do you seek other than a divorce? Is there a property settlement agreement been
Yes,
done?
filed, well, no, he didn't sign it, I put it in the decrease of the term. There's a deposition of the girl.
I know you, so you want a default decree, but they didn't say default on it. I just, both parties in the fit class.
We don't know if he will or not, he's not in business. He knows that. Call.
Did you put in the decree that his visitation won't happen unless he does?
Yes, Your Honor, it's in there. And it's on next to the last.
How did you serve him as for it? I
He
mean,
served on the sheriff, right now.
and he never filed any answer at all. Okay, well, we'll take this under submission then. We'll review it. It appears to be in order.
The
Okay,
good language is on page 2.
okay, thank you very much. Lahorn versus Lowhorn.
It's withdrawn, Your Honor. We filed a motion for
You
default.
notice I did the Clinton County pronunciation and the Cumberland County pronunciation.
Lowhorn, Lawhorn, Lawhorn, are all completely different. And you go to America, and the Crawhorn. Crawhorn, that's
With a Crawhorn with an L, so,
no, it's a C.
okay, Lahon then.
There's no horn.
Pierce versus Pierce.
Your Honor, Mr. Cross and I have reached an agreement as far as,
Blue versus Price. Okay, what we got going on here?
Your Honor, this is their motion for statements survey bill, which is about 3 or 4 years old, to be paid from timber proceeds. This is a long drawn out case, which was originally filed as an indivisibility or petition action, perhaps a true petition, which is what it's going to end up. We've got an agreed judgment, which is doing well, but there was an omission in that of money being held to pay Mr. State, Clinton Survey for preliminary survey work. He's been very patient, but A, he needs to be paid, and B, we believe Ms. Price ought to have to pay it all. We have to file motions, do things. You know, it's not Mr. Bell, I know, Ms. Price is extremely uncooperative about this. I don't understand it.
Just briefly, there's 3 tracts of land here. There's 2 sisters. Each of the 2 sisters own both tracts of land. There was a 3 or 4 acre tract of land in one of those 2 tracts. Her sister, Janet, had that tract surveyed, considered 3 acres, and turned that being about 7 acres. Now, this has been going on, like Mr. Cross said, for years. But several months ago, we entered into a agreed judgment signed by you. We negotiated for a long time, and I kept telling Mr. Cross that my client would not agree to pay half of the survey cost of that little 3 acre tract that belonged to his client. The bill was $1,200.
I thought it was more than that.
I'm wrong.
And it thought it was 500.
But, you know, there is never was an agreement for her to pay half of his client's survey costs for
I must correct, or I must not agree with Mr. Bell about this. 2 tracts of ground jointly owned and a smaller tract owned by my client, Ms. Blue. That had to be surveyed in order to know the boundary of the other tracts. It was impossible to ascertain where these other tracts were unless you ran three lines of that. It's all contiguous, and this little 4 acres was plugged out of one of these tracts, so it had to be done.
From our standpoint, it really has to be done because, like I said, there's 2 tracks. We agreed that the 2 systems would kind of, this is the way we're going to do it. We'll let Eric Bell go out there and shoot a line, and that's going to be the fish. But it was always our understanding that his client would take the section that contains our 4 acre tract. So it depends on us work with that.
Your Honor, there's the other thing Mr. Bell omits is the timber that's now being cut is divided equally between Ms. Price and Ms. Blue. The timber.
Is that correct?
Yeah.
So they had to know the boundary line to cut.
The timber, that-
You know, it's just $600 each, right?
That's correct. But we have never agreed to pay.
Well, good. You won't have to agree. I'm going to order it. And that way you won't have to agree to it. And she can appeal it if you want to. I understand that you have an obligation to represent what your client says. But quite frankly, it'd be dangerous for you to cut timber, man, without a survey establishing that line over there that you're going to split. Because if you got over on a trespass situation, it could be very. Okay, thank y'all very much. Okay. First and Farmers versus Stinson. So,
This is my motion. This is just an old case that's been on dock for a while. They had an agreement to transfer the property. I need to transfer the mortgage to the father.
okay, thank you very much. Okay. Absolutely. Have a good day. LVNV Funding LLC versus Ellie Thornsberry.
Which was one that's a motion for default judgment.
Okay, let me have the file here. Is this a tax lien case?
No, sir, it's a collection case, and I believe it's
But it has proposed tendered order on the front of it. Is that all right if I sign one with proposed tender order on it, or would you rather give me another?
I'm not sure why they started that way, but I think that's fine.
Okay. Okay.
Thank you, that's all.
Have a great day. Yeah, be careful. Whitlow versus Whitlow. Be fine.
The Catherine case that we're still waiting on, and then we have a confidential document start.
Okay, let's go off the record. Who represents Catherine? She represents herself. You represent the other side, right? Is that the
The Anderson.
Anderson? She.
has no authority to fetch that off.
It's all right. I got a couple minute break on the bench here. I thought something might be wrong. You okay? I'm good. I don't know. I don't know. I might know somebody like that. I don't know. What, how did it come in context? Hold on a second. I'm, who is Greg? Hold on a second. Who's Greg Saunders?
Puppy, WL school.
Oh, okay. I didn't recognize. Yeah, I do know him. I know his dad better than I do him. They call him that. He's a car. Yeah, I'm here with David Cross. I just didn't recognize his name because you know somebody. You can rely, you can rely upon. Okay, okay, buddy. Okay, see you later. Bye. That was Rich Evans. He was gonna buy a bunch of cars off. He just wanted a reference.
Rick called me the other night, up the office call.
Yeah, that's what I heard.
He called me the other night. He was probably way of it, her significant other, whoever he is. He's buying a bunch of stuff off them. I think.
Yeah.
I don't know what.
Yeah.
Anyway.
That's Rich Evans, who I've always buy my cars off of. He's got what he calls executive car search. He's originally from Owensboro, actually from Calhoun. And they had car dealerships, he and his brother did. Now they sold out of car and they make more money. But executive car search. So if you need a no mileage Mercedes or low mileage, something they can find you.
Greg's got a lot, Nicholas Field, he's Greg, put a little man down here, he's done okay.
Yeah.
He's done okay.
I don't think that person is gonna show up.
I just read it.
What is it?
She wished I would die, but she was with me here, so since she was gonna walk my 15-year-old daughter, I told her to leave and not come back. She said she didn't have to, and started headbutting on walls and doors. I brought her outside and she was sitting in my driveway, told her to get out of my driveway. I had to take my little boy to football. She backed up and pulled back in a bunch of times and then took my crutches. She said she was gonna re-break my leg, that it's already broke. Started kicking my leg. I pushed her back and on the ground to keep her from hurting it, and then she started punching it in my crotch and then bit a large piece of my arm.
What time is it scheduled for?
The video was at 1:15 and the custody was at 1:30. Like that.
We'll call it a 2. I'm gonna, these cases concerning Catherine versus Anderson, I'm gonna sign the orders at 2 o'clock if she doesn't appear. She's way overdue. Anyone that's not involved in the confidential matter needs to leave the courtroom. And then
That's Mr. Catherine, you might explain to him.
Mr. Catherine, I'm going to give your significant other, Miss Anderson, until 2 o'clock. If she's not here by 2 o'clock, I'm going to sign the orders. Okay. You can wait right outside. Y'all keep an eye on that situation because there's some serious allegations as far as hers concerned, as far as violence. Yeah. Yeah. So y'all need to keep an eye out for her. Okay.
She has been on the run, sir.
I kept it because of the DVR.
You got warrants for it?
No warrants.
Yes.
But she knew that there was an EPO on her. She got served one night and then lied to the district court judge the next day about getting served when the judge didn't know that.
Yeah.
And she's been on the run ever since.
I'll take care of it.
We heard about it.
But she'll come from
They'd already sent it.
They'd already seen it.
I think you might check the file, but I know Brad had a signed copy.
Okay, I'm gonna call a confidential matter.
I know nothing about that case still.
You just have one confidential case today?
No, we have several.
Yeah, I'll call confidential case 2080-0009.
Yeah, that's the Mitchell.
Is that this case?
The Mitchell.
No, this is Tate. Yeah, Tate,
Mitchell.
Cameron Tate, Mitchell, yeah.
Yeah. Yeah, she. So there's two cases involved in the same parties.
Yeah.
I've been talking about it. He told BJ about it.
Okay, this is 2080-009 and 2080-0010. Ray Cameron Tate Mitchell and Peyton Thomas Mitchell. Mr. Garman.
Judge, this is our, we had noticed this for a final hearing today, and we're prepared to proceed. Mr. Cross is on the other side of the case.
He's had a tough day today. There he is. Mr. Cross, I have called 2080-009 and 2080-10.
Yes.
Okay. Who do you represent?
Your Honor, I represent the respondent.
Where is the respondent?
He and his mother should be outside.
His name Cody Thomas Mitchell.
Norma and Cody. Mitchell. Oh, here's two, Your Honor. Your Honor, I advised my clients to be here at 2. I heard the matter was on 2:30 is what we noticed, so I apologize for not your distinction.
Is it noticed for 2:30?
It's noticed for 2.
It's noticed for 2.
No, I noticed it for 1:30 Central.
Oh, 1:30. All confidential cases are heard at 2 here.
My understanding, because this period, it was,
He said he noticed at 1:30 actually, so.
he did, because hearing is my understanding was after.
How do you understand that? You can't tell people not to be here at a certain time. If they're noticed at that time, they need to be here because so many things don't get brought up. I'll give them some time to get here, just like I do everybody else.
You could take up the other one.
I'll take up the other one. The other one is Henry Graceland Angel. 21 AD 002. Okay, Mr. Garland, what do you got?
Just one motion. Hey, is one to white alcohol?
Okay, this is 21 AD 002. What do you have?
I think there was a previous case in which the biological father.
Who do you represent? Tell me. Who's good.
I represent, Terry Charles Martin, the stepfather.
So you represent the stepfather.
Yes, before the law. The biological father previously held one term in his trial. This is all the same parties. We're asking to intervene on our
Judge,
I don't understand what you're saying. I'm sorry, I'm not following.
Okay, I think we've had this case a month.
Okay, it doesn't matter what, just let's start off with 0. Once upon a time, because I could have had a bunch of cases 2 months ago. I don't remember them. Okay. Does that frustrate you that I don't remember it?
No, no.
Okay, well, good.
My client is the stepfather. Previously, there was a case in which the biological father filed against the mother of the child to terminate his parental rights. He was represented by Ray Grant.
Okay, now what's the stepfather want then?
The stepfather is wanting to adopt the child.
Okay, now, do you have any problem with this motion to intervene?
yes, Your Honor, this was my client filed, or Mr. Angel filed a voluntary termination case. We plan on dismissing that case. He has since changed his mind and no longer wants to go through with that. As such, and there's never been a responsive pleading filed in the case. As such, we plan to, pursuant to the civil rule, just simply file a notice of dismissal.
If I recall, I believe you let them know that you weren't likely to grant the termination
I think that's correct.
because the father was asking it and it more came up to a child support issue.
I think that's.
I wasn't here.
Yes. Yeah, he came up and said he didn't want to pay any child support. And I said, well, that's not a good enough reason as far as I.
And I think that's why
And you let him know what your inclination was, and then we got word that the matter would be dismissed.
yes.
So we
and
never
I
moved
don't
on
know
it?
why that hadn't been filed yet, but we plan to file that.
Okay. Now, you want to do it, now what you want to do is your client and supposedly his wife want to do an involuntary termination, right?
Yes, Your Honor.
Okay, which your client probably would not object to.
Judge, again, I'm standing in for Mr. Ramsey. I haven't.
Well, okay, you don't have authority, but what I'm saying is there's no reason to dismiss this. If what your client ultimately wants because of a bad purpose wants to be done by 2 other people who want to adopt the child and accept that responsibility, there's no reason to dismiss it. And she should be able to intervene if we can accomplish the thing in this piece of litigation. I put it off. You agree? You see what I'm saying? So I will hold in abeyance your motion to intervene right now. And if your client wants to fight the termination now for some reason, I might just let her intervene and we can litigate it here without filing another lawsuit, without serving anybody. So I'm going to grant your motion to intervene. And then you need to get back with her as soon as possible. And if your client goes ahead and, agrees to let them move forward, then we can go ahead and terminate and everybody get what they want. Okay.
So I can go ahead and file my petition and serve them.
That's what I'm saying, but what I'm just allowing you to intervene. I don't know whether I would file a petition yet or not. I would just hold off and maybe get an agreed order of some sort without filing a petition. All you want is just parental rights terminated.
Exactly.
And then you want your client to be in a situation to join in the adoption situation, is that correct?
Yes, Your Honor.
Okay, thank you very much.
Thank you.
There being, there's more of Mr. Simons here and that down at the annex. building. Yeah, tell them they need to go to the annex building.
Okay, that's all. They can take the call in there.
I don't know where he is. Well, he's still involved in that AD case, so he should be around.
He's out in the hall. This is the only case we got left.
No,
The woman hadn't shown up
the
yet.
woman that had, yes, those are the only two.
Sure.
Thank you.
We need one.
You don't have any value on you, do you?
I pulled the order out.
Yes, if it's a good day.